Okay, sounds good. Thank you.
Can I go now? Good afternoon, everybody.
Recording in progress.
Good afternoon. I want to call this meeting to order. Let the record show that we have one missing board member, Patty Graff, and Lauren Romaine is on Zoom with us today. I would like to ask Michael to lead us in the Pledge of Allegiance.
Sure, please stand.
Thank you, Michael. Now, at this time, we will take opening public comment. Public comment will be taken on those items that are within the jurisdiction and control of the Vacation Home Rental Advisory Board. Public comment is limited to 3 minutes per speaker unless additional time is granted by the board chairperson. The Vacation Home Rental Advisory Board uses timing lights to ensure that everyone has an opportunity to speak. You will see a green light when you begin, then a yellow light, which indicates you have 30 seconds left and should conclude your comments. Once the light turns red, please sit down. In addition to opening public comment and closing public comment, additional public comment periods may be allowed on individual items at the discretion of the chairperson. So let's start with opening public comment. Ellie?
Good afternoon, Ellie Waller. It was requested that I turn in some information because I do attend and follow all the other jurisdictions. I provided Mickey with a hard copy today. Summaries aren't easy. I put a lot more information in there, and so it's about 9 pages. I'll send the information to Jen Davidson for review and then distribution to the rest of you. Again, I want to commend the county in general, as well as your service on this advisory board. We are by far the best in the basin. We have stricter rules. I mean, everybody thinks South Shore is the champion because of Measure T. They are eliminating as they go, but the rest of their rules aren't as rigid. Their fines aren't as strict. And just wanted to pass that on. And then I just had a general question that can be answered during the process. When we come here and this board changes things in a permit, I was wondering how long does the applicant have to change their online ads and any information provided in their homes for the occupancy as well as the parking and any other issues? Thank you.
Thank you, Ellie. Any other opening public comments? Seeing none, is there any on Zoom?
Thank you, Madam Chair. Ann Reno for the record. I do have a caller that I will ask to see if they would like to make a public comment, opening public comment. Caller, at the last 4 digits of 3935, would you like to make opening public comment at this time?
Yes, I would. Can you hear me?
Yes, we can. Thank you. Your 3 minutes.
Okay, great. My name's Phil Oliveri. I'm a resident in Granite Springs, 150 Granite Springs Drive, State Line, Nevada. I am calling on behalf of the property owner of 151 Granite Springs. In the last meeting in February, it was said that the lot west of 153 was forest land. It is not. The property is in escrow. It should be finalized very soon. And the owner, Pervance, has asked me to call on his behalf because he was unable to make this meeting today. So he's very unhappy and very concerned, has written a letter to the board, the negative impact to his future property if the Tier 3 application is approved. And I just wanted to make sure that that goes on the record.
Thank you.
Secondly, I just have a comment before I cut off here that many of the residents in Granite Springs took a lot of time out of their lives last month to be on that meeting, to be on the call, and to voice our opinions and our concerns. And I think it's unfair that the property owners of 153 took the opportunity to bypass that meeting, probably in hopes that none of us would voice our opinions today. So just for the record, I think it's fair. I think that it should be counted and documented that we were on the call, he was not, or they were not. Thank you very much for your time.
Thank you, sir. Ms. Reno, any additional Zoom comments?
Thank you, Madam Chair. Ann Reno for the record. There is no additional comments.
Thank you. Then seeing no more public comment, opening public comment, I'm going to close opening public comment and move to the approval of the agenda. One thing I would like to say is we're going to switch it a little bit. Item number 1 is going to be moved to number 2, and number 2 is going to be moved to number 1. And this is for possible action, approval of the proposed agenda. The Vacation Home Rental Advisory Board reserves the right to take items in a different order to accomplish business in the most efficient manner, to combine 2 or more agenda items for consideration, and to remove items from the agenda or delay discussion relating to items on the agenda. So I will look to the board for a motion.
Madam Chairperson, I move that we approve the agenda, noting your preference to flip items 1 and 2.
And I second that.
Thank you. I have a motion by Keith Beyer and a second by Michael Sloan. If there's any discussion, Lauren, do you have any? Okay. All those in favor?
Aye.
Aye. Opposed? Thank you. Okay, so item number 1, I have to get myself in the right order too. What? Oh, the minutes. I'm out of control. For possible action, discussion to approve the draft minutes of the February 23rd, 2022 meeting of the Vacation Home Rental Advisory Board. Michael, I believe you have some comments?
Yes, Madam Chair. I did find, I think, an error. On page 13, when we went to defer the item for Granite Springs, it says it was denied 5-0, and it was really approved 5-0. So I'd like to get that noted. Do I need to make a motion on something like that? No.
Okay, so you just need to make a motion subject to that change.
I'd like to make a motion that on page 13 of the minutes that the result was approved 5-0, not denied 5-0.
Okay. Do I have any discussion or a second?
I second that motion.
Okay. No more discussion? Okay, all those in favor of approving the minutes with the one change on page 13 where it says denied, change that to approved, 5-0. All those in favor, signify by saying aye.
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 All right, 4-0, and approval of the minutes. Now I'm going to item number 1. For possible action, discussion on ordinance 2022-1599, an ordinance amending provisions of Chapter 20.622 of the Douglas County Code, including the setting of occupancy limits, allowing vacation home rental permits to be issued to closely held corporate entities, grandfathering in existing multiple VHR permit holders through October 1, 2024, subject to the conditions and terms of renewal, clarifying the liability insurance that must be held by VHR permit holders, increasing the length of the term of the VHR advisory board members from 2 years to 4 years, imposing liability for persons who assist in the leasing of VHRs without a valid VHR permit, modifying the fine structure, increasing the time in which a notice of appeal must be filed from 10 days to 14 days of the date of the first notice of violation was mailed, increasing occupancy from 2 per bedroom to 2 per bedroom plus 2 for properties with 4 or fewer bedrooms, limiting occupancy to 4 persons per on-site parking space if occupancy exceeds 2 per bedroom, and other related amendments clarifying the intent of the regulations. Mr. Ritchie, I feel like I just did all your work.
Yeah, you did. Thank you. Thank you, Chairwoman, members of the advisory board. Doug Ritchie with the Douglas County District Attorney's Office. What's before you is proposed revisions to the VHR ordinances. It's very similar to the proposed revisions that this board looked at previously. There have been some minor changes. The red line demonstrates all of the changes to the ordinance, but I thought I'd highlight a few things. The proposed revisions are a little bit more restrictive in some areas. Perhaps the biggest one is that Judge Jones capped the fines at $50,000, from $50,000 to $5,000. We're restoring that again to $50,000. Sorry, I said 50, didn't I? 20,000. The number of Tier 2 and Tier 3 VHR permits will remain at 600 and not be increased to 650. That's found in 20.622.030A. The tier levels are remaining. For instance, a Tier 1 would be up to 4 occupancy, Tier 2 is up to 10 occupancy, and Tier 3 permits are 11 or more occupancy. There was another change. There was a desire to allow a transition period for individuals who held multiple permits. Previously, it was suggested that they would have until December 31st, 2031. That has been changed to October 1st, 2024, in which to make those changes. It's roughly 2.5 years to either change their business model, sell their property, or decide what they wanted to do. Of course, this board will be making further recommendations to the Board of County Commissioners, and you may decide to change that as well. VHR occupancy will remain at 2 per bedroom, but it's proposed that an additional 2 person per property may occupy the VHR property if the property has 4 or fewer bedrooms, i.e. it's a Tier 2, and occupancy is tied to available on-site parking if the bonus 2 persons bonus is used. In other words, if you want to use the +2 provision, you have to be able to show that there's available on-site parking. This was previously in the proposed revisions, but I want to highlight it again. Liability is now expanded to those individuals who assist VHR property owners with the marketing or management of VHRs when they do not have a valid VHR permit. Previously, the VHR penalties only applied to the actual VHR property owner. Now it applies to property managers that assist in the illegal renting of VHR properties without a permit. VHR permits continue to be non-assignable and must be renewed annually. Closely held corporations can own a VHR permit if the entity is owned by family members and the members agreed to personally be responsible for the entity's compliance with the VHR regulations. I think those are the major highlights. As I indicated, there is a red line available. It shows every change that's being made to the county's VHR regulations. I believe these changes address some of the concerns that were raised previously by members of this board as well as the public. I think it's a good opportunity for this body to kind of set the foundation for the VHR program, continue to see how it operates, and then make some further recommendations to the Board of County Commissioners. I'm available for any questions.
Thank you, Mr. Ritchie. Did you say that it upped the cap from 600 to 650, or did I mishear you?
I probably said it wrong. It was 650. It's going to stay at 600.
Okay, thank you. That was the only thing that jumped out at me.
Yeah.
Michael?
Thank you, Madam Chair. Thank you, Mr. Ritchie, for working on this settlement. I do have a question. You mentioned that Tier 1 was going to stay at 4, but it doesn't really say on page 88 of at least my form. It doesn't really specify it's for Tier 2 only, and so my question would be, the way it's written, it appears as though Tier 1 could go to 6, and so I just wanted to know if that was part of the intent or not.
I'm looking at Tier 2 definition, but it's basically 4 or fewer bedrooms. So you'd have 4 is 8, and with the bonus you'd have 2. But the actual regulations, property has 4 or fewer bedrooms, if I remember right.
I think that's correct, Mr. Ritchie. But if, say, you had 2 bedrooms and you were a Tier 1, so you had 4 at one time, and now if you're a +2 with 4 or fewer bedrooms, and you have 2 bedrooms and you're a Tier 1, you would go to 6. Was that the intent, or is that? It appears as though that's how it was just left.
The intention was to keep the tiers as they were originally in the ordinance as adopted last July, June.
Okay.
The +2 is a new provision, so you could, I guess, go up to 6, assuming you met the other requirements.
Do we have discretion to make recommendations so that it excludes Tier 1, or how will we do that, Madam Chair?
The settlement's been approved by the county commissioners. So it's probably in our best interest to approve this ordinance as brought forward to us and then make recommendations as we do throughout the year when we turn them into the county commissioners, because we're not precluded from making changes down the road. And it was a good question as far as the Tier 1s. Keith, did you have? Oh.
Go on. I'll prep for the next one.
I got 2 questions, but also I don't read it, the interplay between those as you just did. On page 81, Section D, we are going to allow legal entities or members of those legal entities as long as they reside together. And I'm not going to go to, I think, ludicrous things that what you can't enforce doesn't matter. A provision, most people comply with the law. And so, but I'm a little worried about how you enforce it. I mean, would the county seek to have, a lot of times when you prove your address, you give a electric bill. Well, your electric bill's only gonna be in one of those people's names. So do you have any idea how you would enforce to see whether the members of those corporations all physically reside together rather than just sharing a last name?
Chairwoman, if I may.
Mr. Ritchie?
Thank you. Doug Ritchie with the Douglas County District Attorney's Office. We're aware of that difficulty. The idea, though, is that eventually, if there's a violation, and we believe that somebody that was holding, they held a corporation, they had no familial relationship, they didn't live together, there was no tie to them, we'd probably end up in court and have to do discovery and verify their relationship. You ask a great question because it's very difficult in the modern age to define what is a family. But the intent is that these are closely held corporations. It's basically families that own these properties, not in a trust, but for tax purposes or legal purposes as a corporation or partnership or an LLC.
I absolutely understand the issue with trying to define a family, and I agree with you 100%. I guess my concern was, since you can't, we're looking at sharing living quarters, and it's hard to believe that a family trust with two adult kids actually live in the same house. And so it was more a verification that they actually live together. You know, since we're saying living together means a family, which I agree with, the difficulty around trying to prove where you physically address, I'm well aware of people having voter registrations not really where they reside. I'm aware of, different people. And again, as I've tried to do this with my kids and everything's in my name and trying to prove where they physically live, it was difficult. So, okay, so enough on that one. On page 88, D1, we are adding the language, plus 2 additional occupants per property if the property has 4 or fewer bedrooms. No more than 4 occupants per on-site parking space will be allowed if occupancy exceeds 2 bedrooms. So if you have 4 and you want to go to 10, you can't have more than 4 per parking space. It says, however, waivers pertaining to any occupancy limitations may be available if the owner provides designated off-site parking within the Tahoe Township. That last caveat is not on page 99, which is the official settlement. It kind of sits there, but it wasn't part of the settlement that the county commissioners reached. And I guess I'm more concerned about this one because I don't know what designated means. Does that mean I only have the right to park there, or there's a parking space available that might be shared with 27 units? So I was kind of uncertain as to how we would know what defines a designated parking space and why that phrase, however, is in the regulation at all, given that it's not in the settlement agreement itself.
Thank you. Doug Ritchie with the Douglas County District Attorney's Office. Those are great questions. The settlement agreement may not contain all of the language. The settlement agreement actually references as an attachment, this is the draft language. So that hopefully that addresses that question. As far as the designated parking, the issue that was brought up is I may not have parking at my unit or on my property, but I have permission or I own a property, say down the street, where I allow parking. Whether that's a vacant property that the owner may have, or you have the right to park there. That was the intent there, is that if there is available parking, maybe not at that property, but close by, that they could park their vehicles and not be on the street, then that would be allowed.
And again, I agree with the chairperson, absolutely specifically. They've reached a good faith settlement. I think it's in everyone's best interest to move this thing forward. I just want to point out designated as a very loose term, and I don't see a difference of someone parking in the Tahoe Township 6 miles away and someone saying, well, they're going to park at the casino. People who rent want to park their car next to the unit, not in some designated space, because there's no limitation. It's just within the Tahoe Township. You're either in walking distance or you're not. And I don't see the difference of Unit A, who might own a property 7 miles away and you can park there, and someone who says, I don't have a property 7 miles away, but they can park in the casino and I'll go pick them up. The convenience is that we know that renters often don't either know or understand the rules, or they don't comply with the rules. And my concern with this, that we'll talk about as a potential change, is that if it's in Tahoe Township, you're still going to have parking issues in these neighborhoods, because while there's a designated spot 6 miles away, I don't want to use it. I want to park in the street outside a unit. So, but again, I am in full support that this is an agreement. Just real quickly, I didn't read and I'm glad, I understand these are different, but the way I read the interplay between a tier one and this bedroom capacity is it doesn't say tier one is anything per bedroom. It's a 4 maximum. So I did not see that this additional 2 would affect a tier one, because tier one doesn't say 2 per bedroom. It says maximum 4. So I did not see that, but I think that would be great to clarify, to see if a tier one could go to 6. And I'm not saying there's a difference between 4 and 6. I know there's a difference between 4 and 100, and it's gradual, right? So I don't know where it is, but, you know, I think that would be something that we would want to look at, and again, to get clarification if a tier one can have 6, and where is a good cutoff? Because there's a lot of tier 2s. There's a lot of tier 2s that are 6, because that's 3 bedroom, or would be 8. But I mean, so I think we ought to clear that. So that was a great point. That's all I had.
Thank you, Keith. Michael?
Yeah, I would hope in the future that we can keep tier ones at 4. I think that's what the intended was. I just not sure in the wording of the settlement if it could be looked at a couple different ways. So, Tom, do you have any comments on that? With the chair's permission?
Yes, Tom.
Thank you, Chair. This is Tom Delaire for the record, and I would enforce this as a tier 1 is up to 4. A tier 1 can apply for a tier 2. They have to pay a little bit more money for that. So if they want to use or utilize, even if it's a 1 bedroom and you want to utilize that additional 2, is my understanding from the code here, if it's really applicable to tier 2. So tier 1s can still have like a 2 bedroom without the additional 2. Or if they want the additional 2, then they apply for a tier 2 and get a tier 2 and still live on the property. It's not a problem.
Thank you, Mr. Delaire. Michael, you
Well,
have some more comments?
Of course I do. Let's see here on, was it 82, where it says in red, issued to the owners of the unit, second line, which is not transferable. It's kind of vague. It's not transferable. Should we have not added not transferable upon sale or upon anything else? Just kind of looked like it got stuck in there.
If I may.
Mr. Ritchie?
Thank you, Chairwoman. Doug Ritchie with the Douglas County District Attorney's Office. It's not it's transferable at all. So even if there's not a sale, if it's a gift, any kind of transfer, the new owner needs to get a permit. Just in case it wasn't clear, if someone has a VHR permit, they need to apply for it. They need to qualify for it.
I want to point out the specificity of that language, because one of our prior agenda items had someone who created an LLC, and somehow the property moved from his name to their name. And, you know, his attorney was here, and we weren't sure what it was called, and I said it was a sale, but transferable. Would you believe that someone who changes legal ownership, but they retain control via different corporate structure, would that be a transfer as well?
Mr. Ritchie?
Sorry, I don't know if did that make sense?
No, I think.
Okay, because if you weren't here for that meeting, you may not have, so we had a conversation where someone had the property in their name, they created an LLC and contributed, I think would be the legal term, that property as the foundation capital of that LLC. Mm-hmm. So it went from their name to an LLC's name, but he still maintained control, because he's a sole entity.
Sole proprietor.
Thank you, sole proprietor in that LLC. But would that be because I think if it means that, we need to make sure people are aware that they're going to lose their permit and have to reapply if that's the case. So I just wanted to make that. Go ahead, I'm sorry, thanks.
Mr. Ritchie?
Thank you, Chairman. I actually do, and it's very insightful. I can see why someone would argue that. Here's the thing, though. LLCs, corporations, are legally separate persons. So, for instance, if I had a corporation called Doug and I was the sole owner and I transferred it to Ritchie Corporation, and I was a sole owner. Legally, that's a transfer from one entity to another entity, even though the underlying ownership may be the same. The director has a lot of discretion on how to apply these regulations, and I would, I think this board could defer administratively to how that's applied and administered. And to the extent that it becomes a problem, or there continues to be ambiguity, that's your role to help clear up ambiguity and tighten up regulations where needed.
Thank you, Mr. Ritchie. And I would say, let's maybe move on from this subject because it is something we can talk about when we're making recommendations, not necessarily today, but down the road. Michael? Oh, I'm going to get to you, Lauren.
I don't have anything else.
Oh, okay. We're getting to you. Lauren, what do you have?
I really don't. I did talk to one of the litigants a long time ago and said that this whole lawsuit has just been a distraction and we need to get this process up and running and move through a process where we actually look at the issues, study the issues, review the problems with the proposal or the positive impacts and make substantive changes to the ordinance. And that this has just slowed the whole thing down. So I'm really looking forward to getting it behind us. And I appreciate all the hard work of the DA's office to get that done and whoever else was part of that. So thank you.
Thank you, Lauren. I just had one little comment about the off-site parking we were talking about. And I might be dense, but, and it's a good possibility. But I thought the off-site parking had to do with like condos and townhouses where there was communal parking and you don't have on-site in the driveway of somebody's home. That's really all I have to say about that. With that said, if there's nothing else on this from the board, I'm seeing if public comment. Do we have any public comment?
I do. Oh, we gotta go up. Oh, I'm sorry.
Yes, you can come up to the microphone when you're ready. Ellie?
Ellie Waller. I want to thank everybody as well for all the hard work from the stakeholder group to get us here, as well as staff and the DA's office and anybody. Thank you, Lauren, for that intro. Again, I'm hoping we will have maybe an agenda item when we don't have so many to do like a bundle of amendments, so you're not going back to the board and everybody, and I'll have similar suggestions, like changing the language to identified off-site parking and show where that actually is. If they're sending someone to a casino to pay for overnight parking, I think that's great, but the word identified might help. So they're not parking in somebody else's neighborhood. I lived down a street in Tahoe, 13 homes. I was the only full-time homeowner, and people parked in driveways of empty homes. So we want to make sure we definitely avoid that kind of thing. Even, I don't care if you're really friends with your neighbor should have to sign an affidavit. I mean, I know we're getting into the weeds, and this one's going to be just like the bedroom issue, how we're going to identify or where somebody's identified a game room and turning into a bedroom. So that, again, is getting into the weeds. I'm looking forward to just having a work session, maybe independent of an advisory board meeting, because we got to get through this. We still have a bunch. And then once they're all done, there'll be less confusion on renewals and all of that. And if everybody's game, maybe we just need a workshop and the public can come make I don't know exactly how this county works, but we've done that in the past where I used to live. That way you bring the public in, VHR homeowners, so on and so forth. And I just want to comment that Commissioner Tarkanian did explain at the Board of Commissioners meeting, there was a trade-off made, and I was horrified at the 10 years, honestly, so I'm glad it's two trade-offs and compromise is what happens in settlement. Thank you.
Thank you, Ellie. Please state your name for the record, and when you start speaking, you'll get your 3 minutes.
My name is Dill Roberts, and two things here. Did come up to say one, but two things is the on-site parking is a real issue because think about it. You go down, you go, oh, we have tier 3, we can put 85 people on this thing because it says so. Well, now the bus goes down to the casino, picks up 110 people, brings them in, bus leaves. They only have parking for 4 cars. Well, the bus doesn't show up for 2 days. Those people are in there. Who is going to be the verifier to make sure that they have the proper amount of people per bedroom and the 2 people sleeping on the floor of the couch together? You know, think about it. So that's something that really needs to be considered when you think about parking. It needs to be on site or pretty much not at all, because there's no way to enforce anything after that except for once the party gets out of control and we call the police, and which happens all the time also. The other thing is I heard just on the last little thing on your agenda that you wanted to increase automatically from 2 years to 4 years for the advisory board. I am firmly would like you to strike that out because I think it should be on merit, not automatic. If you have people not showing up for the meetings, if they're not doing their jobs, they need to be basically reevaluated whether they are appropriate or not. When this first came up, I applied. I never saw anything from anybody with a going, well, gee, other than just applying, what qualifications do you have, really? What can we interview you? I didn't see that, and I didn't talk to anybody about who is actually doing the selection process. And I think in the end, before we go and automatically, it's no really reflection at this point upon you as a board, but I think that's something that needs to be considered. We just can't give someone 2 extra years just because. We need to evaluate them. This whole process is new, and you are new to it. Thank you.
Thank you, sir. Any other public comment on agenda item number 1? Is there anybody on Zoom?
Thank you, Madam Chair. Ann Reno for the record. I do have a couple of people that would like to make public comment. Mr. Harmon, if you can hear me, please state your name in full and your 3 minutes will begin.
Hello, this is Ben Harmon from State Line. Can you hear me okay?
Yes, we can.
Great, thank you. Okay, so I guess I would appreciate it if someone could please provide more detail about why this is even on the agenda. I think I missed the connection there. Perhaps this is resulting from the lawsuit, but these changes do not seem to reflect either the input of the task force nor the will of the many people providing input to this board and to the commissioners over the last few years of meetings on this issue. So it gets my blood up a little bit. Okay, let's really look at the proposal to allow corporate ownership. Could the board please explain where this modification originated? Is anyone really going to verify the structure and membership of such a corporation? And how many such corporations exist that are truly things like family trusts? If it is not possible to verify this, if it is unenforceable, then please don't accept this into the regulations. It's just too easy to abuse. Knowing the makeup of those behind the lawsuit that probably led to these changes, my personal and possibly cynical belief is that this is another in a long string of attempts to disguise commercial activity as something else. Maybe that's not fair. Maybe it's fair in some cases and not other cases, but we've got to be able to make that differentiation. I don't like the idea of formalizing what are easily identifiable as commercial operations to function in residential zones. As I've said many times in these meetings, many VHRs are purely commercial operations taking place in residential zones. I have a few questions for the attorney's office, if it's possible to get answers to these. First, are some of the affected areas of the Tahoe Basin zoned residential? If yes, then why doesn't allowing commercial operations in those areas conflict with that zoning? Thirdly, if allowing such operations does not conflict from a legal perspective, then I would also like to understand why we bother with zoning at all. Lastly, allowing multiple permit holders more than 2 years to sell their property strikes me as excessive. Property values are extremely high right now. Properties are selling in a few days, often without asking. So I struggle to understand how asking someone to divest from owning multiple properties could be considered onerous, particularly when it is more likely that the owners of such properties are less likely to be local residents and more likely to be the more egregious abusers of the neighborhoods where the properties are located. Thank you very much. That's all I have.
Thank you, Mr. Harmon. Is there anybody else, Ms. Reno?
Thank you, Madam Chair. Yes, there is. Ms. Gunter, if you can hear me, please state your name in full, and your 3 minutes will begin.
Yes, hello, my name is Heidi Gunter. I'm the owner and operator of World Class Property Management. And I want to thank the two commissioners and county staff for attending the final settlement with me to get this done with so that we can get back to business and county staff can really get a handle on what this ordinance is, along with homeowners, so there's less confusion for everybody. So thank you everyone for what you're doing today. That's all.
Thank you, Heidi. Anybody else?
I do have one caller that I will ask. Caller, that's ending in 3935. Would you like to make public comment on this item?
No, no, thank you.
Thank you. Madam Chair, there is no further public comment.
Thank you, Ms. Reno. With no further public comment, I'm going to close public comment, bring it back to the board. I just kind of want to reiterate what I said earlier. The settlement has been approved by the county commissioners. We don't make policy, we make recommendations. So this is a courtesy that they bring this to us, and I'm grateful that they do, that we can make our comments. So I'd like to ask the board now if this is something they would like to vote on, because we have the option of voting to approve it or.
Sorry, Madam Chairperson, would
Miss-
the motion just be that we've read and we understand, or that I guess, I don't know, are we just showing our support, or what would the motion be rather than just not taking an action?
The recommended approval, I guess we would be recommending that the county commissioners approve the ordinance as revised. So if you want to have more discussion, that's great. If you want to make a motion, okay. Michael?
Madam Chair, I'd like to make a motion. See if it will get a second. I'd like to make a motion that the discussion of the ordinance 2022-1599 by Mr. Ritchie be approved, but also subject to future discussions with the VHR board for possible changes on, that's it.
I'll second that motion.
Okay, I have a motion and a second. Any further discussion, Lauren?
Yes, yeah, the last time it came to us, we didn't do anything, and I really, to me, this is something that is outside our purview. It's something that was brought to a lawsuit that was brought to the county. We didn't make a comment on it before, and I'm not comfortable making a comment on it now because we don't have any control over it. We don't have any input really to it because it's outside that, and I just feel that reading it and moving on is the best thing. I can vote no, so whatever, if you guys feel you want a motion on it, that's fine.
Thank you, Lauren. I have a motion. I have a second. If there's any more discussion, I personally would like to put this whole thing in our rearview mirror and start moving forward. So all those in favor of approving the motion as described by Michael?
Can I have him read it again then, please?
Sure. Michael?
Hopefully it'll be word for word, Lauren.
Sorry.
I move that discussion of ordinance 2022-1599 by Mr. Ritchie be approved, but that the VHR board has abilities to make future changes and recommendations.
Okay,
Lauren, are you okay with that?
yeah.
So all those in favor signify by saying aye.
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 Opposed?
Nay.
Motion passes 3-1 with one absent. Thank you, Mr. Ritchie. Okay, we're going to go to agenda item number 2, which is agenda item number 1. For possible action, discussion on an application to obtain a Tier 3 vacation home rental special use permit. The subject application is for a 7-bedroom home, 14-person occupancy located at 153 Granite Springs. The owner is IDB Holdings LLC, Louis Sarmiento, who currently has a Douglas County issued VHR permit number 084-01811, APN 131826515-031. Mr. Booth, are you giving this presentation?
I'm here. Louis Sarmiento.
Yeah. No, I'm glad to know you're here, but, and we'll call you up in just a minute. Mr. Booth?
Thank you, Chairwoman. Sam Booth, Deputy Director for the record. I hope to help out this afternoon with Tom. We've got quite a few Tier 3s here in a row. And as we've had quite a few staff members that put the packets together, I've been assisting Tom with that. So just hope I can lend some information this afternoon. On this item number 1, as you know, this item was discussed last month and continued from last month's meeting to this meeting this afternoon. As the chairwoman just stated, this is an application for a 7-bedroom home with 14-person occupancy. If you remember, the discussion and the reason for the continuance last month was due to the fact that we were, the property owner was waiting for a property manager to be approved and chosen for the property. I think there was a question I heard earlier under public comment about the reasoning for the continuance. I know Tom had stated that last month, but I just want to reiterate that in agendizing the items last month for the meeting, staff had been coordinating with the property owner, and we identified the need for the property manager, but we had already noticed in the newspaper and sent letters noticing the neighbors of the meeting. And so I believe code enforcement staff had been talking to the property owner and seemed reasonable that he was asking for a delay to the next month's meeting. They had informed him that that would be okay, but we had already sent the noticing for the meeting, so we needed to leave it on the agenda. That's a requirement that's discussed in Title 20. So staff in your packet last month had requested the continuance as well, that we had relayed that to the property owner. Just want to mention that. We do have a property manager that the property owner has found for the site, Brandon Gerard. Would note, let me see, I think I had a few other notes in your packet. In our summary sheet of property information, this is page 28 of your packet. Of course, we've said that this is a 7-bedroom home, 14-person occupancy, and I know the board discussed this at length last month. Total parking is 6 spaces. And there was also a question or comment earlier that I heard in public comment about the vacant lots adjacent to the site. And I just want to note for the record that east of the site, 155 Granite Springs Drive, as it says there at the bottom of your sheet, that is a vacant lot owned by the state of Nevada. West of the site is 151 Granite Springs, which is a vacant lot, and I believe the caller earlier mentioned it's a private property owner that owns that. So that's the vacant lot to the west is private property, but to the east is the open site owned by the state of Nevada. And additionally, you see there across the street, there's another property owned by the state of Nevada. Just wanted to bring that to your attention. And I think that was about it. You'll notice today, as we move through the items, that we've amended some of the exhibits or some of the notes in how we've relayed the attachments in your packet. So in Exhibit 1, and I apologize, this first item, the exhibits had been carried forward from last month, so we didn't have that changed. But what we are noting, and you'll see on some of the other ones, is if we have an exam certificate on file, we've noted the name of whose certificate we have on file. And so there are some notes in parentheses under each of those exhibits as you move through the packet. If it's not there, you should see it and catch it there on your property information sheet, as well as far as the information and the code requirements. Just wanted to touch on that. If Director Dallaire has anything else to add, I defer to him.
Nope. Thank you, Sam. We're available for any questions that you guys have before we hand it over to the applicant.
Thank you, Mr. Dallaire. Keith, do you have any
Of course.
questions? I know we had a lot of questions for the
Yeah.
owner, and we'll do that when you come up, but these are going to be questions for either the fire department or staff here.
So my first question is really process, because and I was really struck by what Lauren said last time, that I may not want to engage a property manager until approval by this. So, and I am sympathetic to that view, right? You're doing a transaction that may or may not have a substance later on, but it just seems to me odd that we issue a permit, they can rent under a tier 3, they can rent to more people than 10, but they're not in compliance with the code while they're doing that because they don't have a property manager. So I just wanted to verify, and again, it's not necessarily about this applicant, it's just all of them. We have situations where people don't have property managers. They want to rent as a tier 3. A property manager is required for a tier 3, yet they can without a property manager assigned. And that's just the way, that's just a loophole in the code, and it'll go away after a year after all these tier 3s, after we get the mass of this new regulation done. Is that relatively accurate?
Madam Chair?
Mr. Taylor?
Yes, Sam Taylor for the record from the Douglas County District Attorney's Office. In response to that, I would just note that this is a one-off sort of transition period from the time that the ordinance passed in July up until the time that somebody started to apply for tier 3s. We gave them 180 days. That was extended out due to mitigating circumstances relative to the lawsuit and the subsequent passage of 2021-1588. So it is only temporary. It's a one-time thing. It isn't going to be permanent. And so it was just a transition period going from the prior ordinance, which had no tiers, to the creation of a tier system and allowing those people to operate under permits that had already been given for a certain occupancy level, say 20, and then they get a chance to apply for a tier 3 SUP, and then this board gets to determine whether or not they can have one or not. If they get one, they get whatever terms and conditions based on the occupancy that they applied for and which are qualified for under the new ordinance. And if they're denied, they go to a tier 2. So, which is 10 occupancy, subject to the changes set out in 2022-1599, which are potentially going to allow an additional 2, except for tier 3s, which, because there's a bedroom limitation in 1599. Does that answer the question? Thanks.
Thank you, Mr. Taylor. I actually had just a follow-up on that. What you were saying was, if somebody mentioned it in public comments. So if someone's denied a tier 3, how long do they have to change their advertising and reduce down their, I can't imagine you turn a switch the next day. Is there an answer for that?
Yeah.
Mr. Dallaire?
Yeah, Tom Dallaire for the record. It is, we try, code enforcement officers reach out to them as soon as we can. It might be 2 or 3 days after this meeting, but we are expecting them to update their ad and stop advertising for that. Now, they have 180 days from when the permit started, and they may have additional occupancy in a month or 2, or 3, maybe even 4. From reservations. We have an item on the agenda at the end of this for that very issue. But the The point, I think, is they have 180 days to operate, and it was basically the transition going from, you need to provide us with a couple of sheets of paper and information, to now you got to provide a book and inspections, and, oh, by the way, you're going to the board, and we had to create a board. And so there was a lot going on, and still a lot. So I appreciate the last action, that we can actually get something for 3 months that's not going to change the code, so we can actually enforce and implement those provisions, because it has been extremely difficult to get a program up and running while we're still juggling on each of the items of the code as well. So thank you, Tom.
Thank you, Mr. Delaire. And I do appreciate that you guys have had a lot of balls in the air, and a lot of them get dropped because of all the changes. So this will be a good thing going forward, and I think we can really find as Lauren would say, we can find our feet now. Michael?
Thank you, Madam Chair. Yes, on page 75, I noticed that the permit was issued to the individual, but it did not include the LLC. And so I don't know if we're on a program now, Mr. Delaire, that we list everything associated with the ownership.
Yeah, when we do these revisions, so these certificates that you're looking at on 75 and 74 were created by HDL. I've given them guidance on what we want it to look like. It's taken them a while to get their software updated from what they have done with other jurisdictions across the country, and we are working with them on a weekly basis to make sure that these are in compliance, and we actually change, like one of these, we're going to change the parking number on, and we'll have this updated, and the LLC will be included on that as well.
Thank you.
Lauren, do you have any questions for staff or fire department? Anybody else? Otherwise, I'll invite the owner to come up and answer some of the questions we had with the last meeting, because we heard quite a bit of information last time that we were hoping to ask you about.
Sure, thank you. Good afternoon. This one? Oh, thank you. Oh, my name's Luis Sarmiento. I appreciate the opportunity to be here today. I wasn't going to mention this at all, but I did want to just start with why I wasn't here last time, because I know there's a lot of angst about why I didn't show up, or I pushed the meeting or whatever. But we got our permit on December 22nd, and then I thought everything was good for a year. And then on February 4th, code enforcement emailed me and asked me for 3 more items. And I said, oh wait, you guys got the wrong guy, because I got my permit in December. And they said, no, there's a board meeting coming up February 22nd, and they need this information as well. So the list, the first 2 were easy, and one of the third ones was you need a licensed real estate agent to be your property manager with a short-term board certificate or something. So I've had a property manager, David, who's actually here with me. He's been with the property for what, 5 years or? 4 years. 4 years. So during all this process of permitting, he's been the property manager, and that's all been great. So 2 weeks before this hearing, they say, I need to find a licensed person. And I said, that doesn't make sense, because we already have someone. And then at that point, Bonnie's like, well, let me research it and see if you really need just a real estate agent, or you need a special real estate agent, or what. So I didn't want to show up to this meeting with one thing missing, and then that would be, a reason to deny our permit. So she offered to extend, and I accepted. So that's what happened. So it was a misunderstanding and learning and growing pains, essentially. Okay, so I just have a brief 5-minute statement, and then you guys can fire away. My name is Luis Sarmiento. I'm an occupational therapist and healthcare administrator. I was born and raised in San Jose, California, and I've been in San Luis Obispo for about 25 years. Yes, I'm from California. Also here today, David, who I introduced. I am a 1/3 owner of 153 Granite Springs. Myself and my 2 business partners are the sole proprietors of IDB. IDB is part of our larger company, Central Coast Home Health and Hospice. In 2008, we started our home health agency, which now has 400 employees in San Luis Obispo and Santa Barbara County. IDB was created to diversify away from healthcare services, real estate, ranch. We got a bunch of things going on. In September 2020, we decided to invest in a vacation property to be shared by the three of us for families and friends. We found 153 and fell in love with it. We were also pleased to find out it was an existing successful VHR. We bought the house fully furnished. We were introduced to the 5-person staff that managed the property, and the listing site was transferred exactly as it was. The pictures in the ad, the description of the property, all came as part of the sale. No parties allowed, no events, no street parking or six-car parking, 30 or over rental age, etc. was never modified. We never made any modifications on the page. The previous owner said there were no neighbor issues when we bought the house. Today, I understand that a home with a max capacity of 20 is too big for this neighborhood. The VHR task force and committees have been working very hard the last 5 years to find middle ground in the community. We welcome the input and believe neighborhoods will continue to improve and thrive. Our property is an example of mandated changes that are already in effect to help the neighborhood. In December 2021, our max capacity was reduced almost 30%, from 20 max to 14 max, 7 bedrooms, which is fair. We have also installed noise monitors, created parking passes, eliminated all street parking 24/7, installed a bear box, and installed video and audio cameras outside the property. Since our permit was approved in December, all of these requirements have only been in effect 3 months. It seems all of the negative feedback I heard from the last meeting, noise, traffic, trash, was all based on issues from 2021 or further back, when the house was 30% bigger, essentially. It's not the same now. It's better, it's more controlled, and to be graded on that discounts the whole VHR committee process and is essentially double jeopardy for us. We were reduced down to 14 in December, which is fine, but to be reduced down again 2 to 3 months later to 10 with no opportunity to show improvement doesn't make sense. We want to be better neighbors and welcome open lines of communication. Lastly, the obvious thing I have to mention is the professional staff of 5 that manage the property and are true members of the community would be negatively affected. I would be very disappointed to let them down. I hope we can come back before the board next year and be an example of a successful Tier 3 property with full neighbor support. Thank you.
Thank you, sir. If a Tier 3 is approved, then you wouldn't have to come back.
Oh, we wouldn't? It's just one time?
If it was approved, you wouldn't have to come back annually.
Okay.
But I know a lot of us have a lot of questions for you because there was a lot of public outcry, and we have to take that very seriously. So I'm going to start with whoever wants to go first. Michael?
Thank you, Madam Chair. Thank you for coming today. Yes, there was quite an outcry last month. I have a question. Did you get a chance to review the meeting on video?
I did.
Okay, thank you very much. I think that gave you a sense of what you heard from the neighborhood.
Yes, and yeah, I was a little blindsided because I've never met any of those neighbors and nobody's ever reached out or said there was a concern. And David's talked to the neighbor across the street and he's always said everything's fine, so I don't understand.
Okay, so I do have a question for David. Are you a licensed real estate broker?
No, I am not, which is why we hired All Seasons Properties, Brandon Gerard, which was what Luis was talking about. For myself, I take care of 2 houses. For me to go out and get a real estate license, find a broker to hang that license, ultimately takes me out of that employment. I mean, it's not affordable to do that for one person. For a vacation property management company that manages many, it is. But for someone like me that works for myself, it ultimately, I lose this job because it's not affordable to go out and get a real estate license, then hang it with a broker and everything else for ultimately 2 homes. But so I am not a licensed broker, and that is what the delay was so that we could find it. I have been property management there, maintenance and other things for 4 years with the previous owner. And like Luis said, we had not heard any of these things. I have met the neighbors and speak with them and have never been told directly about any problems. And I have no problem trying to correct them or do whatever we can, but we just haven't heard anything from them. We really didn't know about this until January.
Okay, thank you. I have a question for staff. Were you notified or were you given any kind of notification that All Seasons is the property manager for this site now?
Yes, Mr. Sloan, Sam Booth, Deputy Director for the record. We were notified that they had chosen Brandon Gerard, and I believe you have in supplemental materials a signature for that. Go ahead,
Tom Delaire. I didn't get it out of the copy machine. I thought it was in there. We do have the authorization letter from Brandon Gerard on file. now.
And would just add, this is Sam Booth again, and we do have the exam certificate that Brandon Gerard passed the VHR exam.
And Tom, for the record as well, we have him listed, we have David listed as the emergency contact. We have a property manager, the Brandon Gerard, per the requirements in our code.
Madam Chair, so that would be changed on any permit that would go forward, the contact.
Tom Delaire, for the record, yeah, absolutely. The permit has to be updated. We'll wait till after the hearing today to update it.
Thank you, Mr. Delaire. Michael, do you have anything else?
Not at this time.
Thank you. Keith?
I pulled the Airbnb listing, and you've changed the title, Spectacular 7-Bedroom, Sleeps 14, Hot Tub, Private Views, host chalet hosted by Luis. In the body, you still have that it's 8 bedrooms and sleeps 20.
Oh, that's an oversight. I'm embarrassed. I apologize about that. There's several boxes on the site that you have to change, and I thought I changed them all.
Okay, because I will point out that people often push these things past the limit.
I understand.
Yeah, notifying that it does actually have 8 bedrooms and sleeps 20 puts people back in that bunk bedroom. Now, have you moved those bunk beds? I think this is the one where there were bunk beds by the window, or am I? I'm sorry, we see so many of these things. One of your bedrooms was not approved as a bedroom.
Correct.
And have you de-bedroomfied that? I mean, are those beds gone?
Yes.
Okay, so if someone actually showed up and thinking they were getting rid of 8 bedrooms, you're only going to see 7. Is that correct?
Correct, and everything's, they have to contact me before they're allowed to stay, and that says how many they're going to stay there, so
Yeah.
if that were to be an issue, they would know.
Can you clarify the relationship? You have a licensed property manager and then a de facto property man. What does your licensed property manager do, given the fact that you have another property manager who may not have a license that really manages the property?
Correct. So I think that's something that's being worked out with code enforcement and with this whole permitting process. Up until, I started the process in March, and going back and forth, a property manager was needed, a local property manager within 30 minutes. It's going to drive by the house, knows what's going on. That was David the whole time. He's always been doing this. Even past when we were permitted, everything was good. And then apparently between December and February, there was a new requirement that says, do you live in Douglas County? No, I don't live in Douglas County, unfortunately, permanently yet. But if you don't live in Douglas County, you need a licensed real broker with this special certificate. And so, okay, so we can do that, but that person, I don't know what they're going to do for us except for sign off on.
So you're basically just paying them part of your rental revenues.
Exactly.
For those services.
Right. David does everything.
So I'd like to add that they are helping me do little things as far as, things that I haven't been doing, but ultimately I'm the one that's going by there. I'm the one that's looking at the ring on a regular basis. If it notifies any of the monitors, the minute monitors, although that goes to my phone, I'm the one that does that directly. I'm the one that drives by and checks on cars. I've spoke with Bonnie several times. If there's a complaint, I've driven by to see so ultimately I am the property manager, but I don't carry that real estate license with the property permit endorsement, which ultimately at this point takes classes, which is why the delay was in the first place, because I'm gonna have to go through all that.
He actually signed up to be a real estate agent just for this. And we're just like, okay, I guess, but.
Madam Chair, I'm sorry. I think it's going to be easier for my questions if I go between the two parties. But there had to be some reason the Board of County Commissioners wanted a licensed property manager. I didn't see their I mean, I guess I would have been happier if they would have said, well, I'm now working under their oversight, but it's kind of like you're still managing the property and you're just sending them a check based on your revenues. So I guess I don't understand, and I don't think I'm going to understand in this meeting why we want a licensed property manager, and you have a licensed property manager because you have to have a licensed property manager, but your licensed property manager isn't managing your property. So I'm a little confused there, but I want to move forward. Because I don't think the county really, I don't want you to put you on the spot and trying to figure out why the county commissioners wanted a licensed property manager. But you said you were a 1/3 owner.
Correct.
And I will ask the county, I thought LLCs, again, the new thing we just talked about, was that grandfathered in, or can you talk about how a 1/3 owner has a permit in just their name and how that would be, that's working now, and would it transition out, or how that would work? Thank you.
Yeah, per Tom Delaire for the record, the county code currently allows LLCs. If you had an LLC, he's had a permit for a number of years, that if he had a permit before July 15th, I think is when the ordinance went into place, he's allowed to have that. Yeah.
Okay,
And searching LLCs is not fun. I can tell you that it is daunting task for staff to investigate all of this and digging into that. But they have all the paperwork. We have all the paperwork needed, putting
Myself as the authorized agent. Yeah, so they have all the articles of the.
Yeah, we have all that on
It's
file.
grandfathered. So if you had an LLC before the new thing, it was grandfathered in, you could continue to operate that in perpetuity as long as none of those owners change. Or the LLC changes.
As long as the LLC doesn't change, I think members can come and go because the LLC is still the same. But that's a whole nother problem that you're discussing earlier too.
Yeah.
I mean,
so you could introduce 50 more LLC unit holders and still keep your permit, and so those are just grandfathered in. They're a way around the rule. These things are transferable. You would transfer the LLC with the property. As long, I don't know if the LLC holds multiple properties, but you transfer the LLC with the property, and this is a transferable permit.
right. Not if it's sold. I think that's unless you sell the property and the LLC together, and then all new members show up, right? I mean, maybe that's what you're talking about.
Yeah. So let's say the LLC holds this property. I decide I don't like it anymore, and I sell the LLC. I've transferred the permit with the property.
Well, somehow we wouldn't know until the next time they renew and we have a whole bunch of new members.
Well, let's say that this is what we're doing. We're selling the LLC.
But
The
there's a
LLC's
whole
own
new
property, it's a
reapplication
person.
process though, right?
Sorry?
The whole new reapplication process has to happen at a sale
The
of
property
a
didn't
property.
sell.
It should, but does the property really sell?
It didn't. I mean, you're
Yeah,
going to sell the
no.
LLC, not the property. This is just a loophole, I guess.
So-
Okay.
Keith,
Let's move forward.
I think we need to focus on
Sure.
this property.
Okay, my next question
And we need to make
is-
changes some other day.
No, I'm just trying to understand
No,
where
I
we
know,
are.
I agree with you.
Okay.
It's very confusing.
Okay,
Madam Chair?
Because,
Mr.
Madam
Taylor.
Chairperson, this is the way we will eventually change the regulations, is to understanding what's happening in reality, so.
Agree.
yeah, Thank you for the
Mr.
latitude.
Taylor would
Yeah.
like to make a comment.
On
though.
page 56,
What?
sorry?
Oh, Mr. Taylor would like to make a comment.
Yeah,
Yeah, if I may, Sam Taylor again for the record, Douglas County DA's office. I just wanted to help clarify your earlier question, Keith, relative to the operational requirements and management of the units. If you look at 2622040, subsection A1, it says an owner may retain a licensed property manager to comply with the requirements of this chapter, including without limitation, the filing of an application for a permit, the management of the vacation home rental, and compliance with the conditions of the permit. Any property manager must be licensed through the state of Nevada Division of Real Estate and comply with state law. And then it goes on to say, a local licensed property manager is required for all Tier 3 units unless the property is managed by the homeowner that is a Douglas County resident. The intent of the property manager requirement was, in the absence of the owner managing the property themselves, doing the bookings, taking the calls, applying for the permit themselves, they could hire a property manager to undertake those tasks for them. But in the context of a Tier 3, they're required to have a property manager to at least engage in some of those activities listed at the very beginning on their behalf if they do not reside in Douglas County, which Mr. Sarmiento does not.
And if they choose to hire somebody and that hired somebody does nothing, that's also allowable.
Well, I would say that's something for this board to consider in the context of this application.
Let's move forward. On page 56, you have pictures of the bedrooms, and page 56 has bunk beds and a pool table. I don't know what's the other side, but is this a game room with bunk beds in it? I don't know if you have the...
It is, yeah. We just thought for kids could sleep in there, and then
Yeah.
the pool table's not the
Okay.
greatest.
That's all the questions I have, Madam Chair.
Thank you, Keith. Yes, I was looking at that picture also. So that's an active bedroom right now with the bunk beds and the two beds and the pool table?
That it was a real bedroom as deemed by the fire department.
Yeah. Oh, boy, here we go again. In the ordinance, it says a bedroom has to be, the primary purpose is sleeping only. So this shouldn't be considered a bedroom because it's dual purpose. And that's all I'm going to say about it at the moment. Michael, did you have something here?
Sure, I do. You don't want to go with Lauren?
Well,
I'll come back later.
Lauren? Well,
Sorry, I wasn't ready. It's okay. I had the same question on the multi-purpose room being a bedroom. I wasn't sure if that was bedroom 8. I guess the other question I had was the emergency contact being different than the property manager. We've gone through that stuff. So the two things I'm really down to is I'm kind of curious, the assessor's page, because we have that page up, says that it's a 2-level home, but we actually have plans for 3 levels. And I just didn't know, that was kind of an interesting thing. And I don't know where to go with that information. And then the other quick thing that I'd like more information on is I do believe that someone who's here, because the last meeting we had, we did say that the 2 properties were Nevada state land, and it wasn't a lot, but we actually now are within Mr. Byers' 100 feet or so, I think, with a new property. And we talked about this with the one that was over at Stagecoach, where there are some empty lots, and we're saying, I think we have them coming back in a year because there might be more lots. I can't remember exactly what we did there because there is the concern. So it sounds to me like someone purchased this and is going to set up a house. So I don't know if there's any way we can get more information on that, because it would, yeah. So I'm not sure if I can, I think those are my comments and concerns.
Okay, we're happy to get rid of the pool table if that will make
was
that
one
a
thing
real
I'd like to
bedroom.
come out. Yeah, that room is a very large room. It's, I think, 22 feet by 17 feet. It's a very big room. So ultimately, we had the extra room for the pool table. It was originally just a bedroom, and we ultimately had room to put the pool table in there. It's got its own bathroom. I mean, it's definitely a room that had enough room to put the pool table in. So ultimately, it's a bedroom that had the pool table added, and if we need to take the pool table out, that's something we can do too. But the reason we set it up is because it's ultimately a kid's room. So a lot of kids come in there and they're kind of away from the rest of the group, and they like to all sleep in there. So we're only allowed 2 for the occupants in that room. However, kids enjoy going down there and hanging out, and it's kind of the kids' room. But we can certainly take the pool table out if that's an issue.
Thank you for the explanation. The ordinance is pretty clear, and we have to follow the ordinance. So that's why it's coming up with the pool table. And I'm showing on your drawing here that there's bedroom number 8, and bedroom number 8's no longer being utilized. Is that?
Correct. Those were all submitted as part of the first permitting process.
Okay.
So,
Yeah,
I
see
need
where
to
you-
catch up and
Okay.
update all my stuff for for the next one that's coming up and hopefully before the actual permit is issued.
Yeah. Thank you. Michael?
Thank you, Madam Chair. Yes, so I believe your property is permitted for 6 spots for cars, 2 in the garage and 4 in the driveway.
Correct.
And one of the many issues that neighbors raised was cars parking all over the place. I happened to go by the property, and it's a supplemental, in the supplemental package, that there were 5 cars in the driveway when I went by, and this was just 3 days ago, something like that. So what are you doing to enforce parking just to be in the driveway?
We've actually done a lot. David's installed a Ring camera in front of the garage, so he has access to see if there's any cars that leak out onto the street, and then we can contact the tenants and tell them to take care of that somehow, or he can go by and talk to them. And that camera also has voice and video, and then we also are finally issuing those county permits, so all the tenants have to write their name and phone number on those and then put them in the car. So if you do walk by and you need to contact somebody because you need to back out your car or drive your big truck by, you can contact those people if we're not responsive enough, but one of us is usually going to handle it. But those are the things that we've implemented that are new.
So your Ring camera can see the whole driveway with all the cars in it?
Correct.
Were you aware that there were 5 cars in the driveway over the weekend?
I was actually there.
So maybe it was your car?
Yeah, we have a big Suburban and my other buddy had a van, so we couldn't, those don't fit all the way in the garage. So my friend that lives down the street had to park behind us, sort of.
Thank you.
Keith, do you have anything else? Lauren, are you still out there?
Mhm.
Do you have any other comments or questions? Okay, I think we should call for public comment. I do want to say we got a lot of public comment last time. We really did hear you. We did take notes. But of course, anybody that would like to come up and make comments are welcome to have their 3 minutes. And we can begin that now, and then if you want to take a seat, and then we can have any other questions, we'll call you back up.
Hi, Dale Roberts again. Just a question for Dave. Where does he live?
I live in California. I live on Ski Run and Highway 50.
So you're within a 30-minute drive?
Absolutely.
Okay, thank you.
Hi, Ellie Waller. I had some of the same concerns, the depictions of the bedrooms. The applicant has been given a second time to go back through this. I know we didn't need to update the package. We probably should have updated the bedrooms for less confusion. With that said, the rules have been presented, so I'm suggesting that bedroom 7 doesn't exist. We are still trying to figure out how to craft the code, work with the fire department on what our code is going to allow versus what you see as the fire department, so we have less confusion. That'll be at a future meeting. We've talked about that. I would like to say, to have less confusion, once there's a year gone through this process, this LLC would have never received the transfer of the permit as well, so that'll get cleared up in the future. The fire department did their job on the failed bedroom. The parking, I do have a question based on 6 cars and access. The parking map, like many of them, we've taken a car out, so there is emergency access to it. I brought the diagram, so I'm not sure why this is 6 and not 5. We have another one in the packet that is removing a car from a driveway. It might be because of a width difference. I'm still trying to get used to understanding the width and the length and how a county is assessing parking. And just because we have had a second chance at this, I read and reread the notes. I did sit through the last meeting, listen to all the people that did make complaints. That really needs to be weighted into this, and because of other things that I brought up, you might have questions, I think this should remain a tier 2. Thank you.
Thank you, Ellie. Any other public?
Turn it on. My name is Maria Tarn, and I have a vacation rental as well, but I just want to comment on Lewis because he's very much like me. With cell phones and Zoom cameras, I have the same situation where I have three emergency contact people, and I'm good to them and they're good to me. And they are 100% better than an agency where you get a phone service overnight, or you get a receptionist that has to leave a message or find somebody. Because the 3 people I have, I can reach them at any given time. If one doesn't answer, the other one does. And I, too, found I wondered why they're licensed, because I think somebody is just as good if they're working just for you as opposed to somebody who has 50 houses. And I did find one, and basically I'm going to pay them $4,200 a year to be on the permit. I am still going to do what I do because it makes the neighborhood better, because I have a vested interest in my neighbors. And I didn't understand that either. And I know exactly what he's doing. He's trying to make it fit for everybody. So I sympathize with him. You know, I really do know my neighbors. All of my neighbors are great. In fact, we stopped to visit the one right next to me, and he said, we're doing a wonderful job. He never hears any noise. And the noise monitor, it's a nice thought and theory, but there's no regulation on what you want it to be. I have it set at 70 decibels, and I have it that low just to be extra cautious, but that's inside the house. It's not even telling you where it needs to be. So inside the house, 70 is just dinner. 80s if you have company for dinner. So it's really hard for us as homeowners to figure out what needs to be done. And I think we need to do a better job at that. And I also called the county. It took me 90 days to get my permit with that company. 2 problems they have: they don't have a server large enough to upload all the documents, so you're doing it in pieces. So they're asking for the same stuff over and over again. And the second thing is they all work remotely. So you might get one person one time that has something on their computer. And so it's really, really frustrating. And then I did call the county after I got my permit, and I too thought I was done. And then I get that call. And I did call and ask about the property manager to the county, and the person that answered said, a lot of people are just slipping through the cracks, you're okay. And then I get a call that I have to do it. That's all I have to say. I know it needs improvement, we're all learning, and I know why you're doing it, and I'm very sympathetic for people who live here full time. And I think I do a good job on our neighborhood. There's not one neighbor that's ever said anything bad. We don't have a lot of neighbors. Most people are vacation rentals or second homes, and I'm lucky there. So thank you guys anyway.
Thank you very much for that information. If you sign in and then state your name, your time will begin.
Hi, my name is Jackie Castro, and I'm actually here to go over my permit, but I just want to reiterate what some of these guys are saying. And I was going to wait till after, but it has been like so frustrating because although you're talking to people in the county and they've been great, Rachel, Donna, they like amazing, so kind, but nobody has the information. The right hand isn't talking to the left. We have been asked, I mean, over 9 times to send the same piece of information. It's like we just like resend the same email. It's like we've already sent this. The third party, I don't know what your HD or so. 2 of the people that I talk to there regularly are nice. Daryl is representing you guys, and he has to go. He's horrible. He's yelled at us. He's sent a nasty email. It's bad, and this is your representation. I don't know the Granite Springs man, but I feel like we're all navigating this, and it's new to you, it's new to us, and we should be given the courtesy of some time to fix, right? I mean, there's been issues. He had no idea his neighbors were that upset. He should have the opportunity to correct it. And at that point it doesn't work, then nix him. I just feel like it's just as hard on our side as it is on yours. I'm a rule follower. I want to comply. I want to do what's right. But it's been really hard to make that happen. And as far, I also have Brendan, he's new to me, but I have to pay him $6,000 a year. I don't want to relinquish my control over my property because it's important to me that I maintain, niceties with the neighborhood and the community. I have cameras. I mean, you'll hear all my spiel when I come up, but just to kind of reiterate what they're saying, there was no clarity as to, we called several times about a property manager. We couldn't get any information. Do they have to be licensed? Do they not? It was because I had local contacts. I live in the Bay, but it's very confusing on our end. Thank you.
Thank you. I know there's a lot of growing pains right now. And we are listening to everybody when they make their comments, and we will be taking them into consideration when we look to make our recommendations. Is there any other public comment in the chambers here? Ms. Reno, is there anybody on Zoom?
Thank you, Madam Chair. Yes, we do have a couple on Zoom, and I do have 3 callers I will need to ask. Siobhan, if you can hear me, please state your name in full and your 3 minutes will begin.
Yes, can you hear me?
Yes, we can. Thank you.
My name is Dr. Siobhan Harrigal. I am the owner of 146 Granite Springs Drive, and I would like to echo the comments and concerns from my fellow Granite Springs neighbors who were at the meeting last month. There is zero neighbor support for this vacation rental. Not one. Mr. Sarmiento and David are clearly out of touch with this neighborhood. There are absolutely parties that are happening at this house. Saying that it's a no parties house is a joke. Saying that the neighbors don't have problems, that's clearly out of touch with this neighborhood. There's zero neighbor support for this VHR. The noise, the trash, the parking, every single comment and concern echoed the same from every other neighbor. This is a quiet residential neighborhood. It is a narrow, winding street. We do not have sidewalks. The streets get even narrower in the winter when there's berms, and the vacation rentals on the street significantly increase the amount of traffic on what's essentially a quiet cul-de-sac. Most of the people do not have air conditioning, so we have our windows open, and the noise from these vacation rentals travels many blocks, and they're extremely disruptive. I'm one of 6 physicians who live within 300 yards of this vacation rental. Hate is a strong word, but we hate these vacation rentals. And this VHR is a problem, and it's been a problem, and these gentlemen are clearly out of touch with this community. Thank you for your time, and I appreciate the opportunity to voice my concerns.
Thank you.
Mr. Harmon, if you can hear me, please state your name in full and your 3 minutes will begin.
Hello, this is Ben Harmon from State Line. I spoke in the last meeting on this agenda item, and I won't repeat those comments that are on the record. I will say that this is a corporation with a non-resident owner, and apparently possessed of what at least strikes me as the peculiar quality of being a sole proprietorship despite having 3 owners, as stated by the owner. This is exactly what I was talking about in my comments on agenda item number 1 today. Is this closely held? Is there even a clear definition for closely held? If there is, how does anyone confirm it? Another speaker said that the owner had no idea that the neighbors were upset. Did he ask them? Or was that perhaps difficult because he doesn't live here? Yes, now there's a bear box, but claims that there are no parties and nobody parks on the street are simply not true. It sounds like the owner has good intentions to improve things, which I appreciate. But there is a reason why this property's been problematic, and others have spoken to some of the specifics relating to the permitting of this as a tier 3, such as the number and nature of bedrooms and the parking capacity. This permit determination will be looked at as an example, and I strongly believe that permitting this as a tier 3 goes against the intent of and the motivation behind the regulations. Thank you. That's all I have.
Thank you, sir. Next.
Caller ending in 3935, did you want to make public comment on this item?
Hello, can you hear me?
Yes, we can.
Hello? Okay, great. This is Phil Oliveri in Granite Springs, and I would like to correct a couple of the misstatements made by the LLC. First of all, the complaints that were at the last meeting were all from this year. You can look at the police reports, including the neighbors directly in front of you. That was a misstatement. There have been many complaints over the years of this VHR. Never mind what your VHR company said. I alone have made over 12 complaints with the Douglas County Sheriff's Department. All you need to do is go to the records and check and see how many calls have been made about 153 Granite Springs. We have seen trailers in the driveway. We have seen cars in the street. We have seen athletic teams come running up and down the street early in the morning and in the evening and walking around the neighborhood because they get dropped off in mass and have nothing else to do but walk around in our quiet neighborhood. We also know that you have a bear box that was installed recently, and it's not used. Your vacation cleanup crew dumps all the trash from the house in the middle of the driveway, and they leave it there for hours while they clean the house and clean the yard and get it ready for the next occupant. We've had a couple of incidents already where bears are just waiting for that garbage to hit the driveway so they can come and have a feast. It is really sad that we have this situation with the bedrooms. You have an 8-bedroom home here in Granite Springs. It is the only one. We do not have these issues with the other VHRs in our neighborhood. I have one next door to me. There are 2 behind me. There's one now on Delissa Court that is also having an issue. So I would say to the board, please do not issue this tier 3 permit. We're putting up with enough as it is already. We don't need more people. We don't need more cars. We don't need more headaches. Enough is enough. Thank you for your time.
Thank you, sir. Another Zoom call?
Caller ending in 0867, if you'd like to make public comment on this item, please state your name in full and your 3 minutes will begin. Caller ending in 0867, you're muted. If you want to make a comment, please unmute yourself to make your public comment on this item. Caller ending in 8515, would you like to make public comment on this item? Madam Chairman, there are no other public comments at this time.
Thank you, Ms. Reno. I am going to close public comment and bring it back to the board. start with whoever has comments to make. I will hold mine till last.
Madam Chair, if I may, Michael Sloan. So when you're driving up to this property, initially you think to yourself, this looks like a pretty good potential for a Tier 3. There was vacant land on both sides, nobody that you could see behind you, and then when you just dig into last month's discussions about all the issues, and then of course a couple today, I just feel that this property has been totally undermanaged. I think it had the potential all the way to be a great Tier 3, but it's been undermanaged, and I just can't go along with a Tier 3 at this time.
Thank you, Michael. Keith?
I feel the same, and I don't know if this is appropriate or not, because I don't think it is the deciding factor on this, but I've also heard public comment from individuals because I do have to shop for groceries. I do walk into Safeway. And I will tell all the BH owners that there seems to be a problem with marijuana smoke. Now, marijuana is legal in the state of Nevada, and if your neighbor decides to smoke it, I'm not sure what you can do about it. I believe the code allows for consumption of marijuana on private property and also if the landlord agrees. But I do think there is a lot of concern about marijuana smoke just because of the smell. And I do think if some VHR owners would prevent consumption of marijuana, their neighbors may be happy. However, coming back to what Michael said, this is, even if this was over 100 feet, the public has been so vocal about this. It was numerous people last time, most of which, could not come again today. But I'm adverse to approving this permit. I do believe that you can apply for a permit next year. It allows you to put a noise monitor in. And I would encourage people who think they were wrongly denied a permit to not have their noise monitors identify events, which is a defined length of time and a defined decibel time. I would ask them to allow those noise monitors and bring us the logs in a year of what the noise actually is that we could look at. But I am against the issuance of a Tier 3 permit for this property.
Thank you, Keith. Lauren?
I have to echo that. And I think one of the things, even maybe someone else said it, but I thought I said, could you please have the owner review what was going on there? The fact that he had advertised 8 and 20 was clearly stated, and I'm disappointed. And I just, this is VHR owners have to understand that there's a responsibility to meld more with the neighborhood. And I understand that he's had 20 and now he's going down to 4 or 14, and now the numbers keep reducing. But, when you really realize that in a neighborhood where, and I'd love to be able to ask some of these people who make the comments, and I'll put it out there for anyone who does make a comment, if they throw in how many people actually live in their homes, how do you meld together when you're not right there all the time, 5 cars, 1 sideways in the driveway, those type of things. How do you manage all of those things when you're not right there? And when you're trying to meld, and all your neighbors have 2 or maybe 4 at the most people in a home, and then you have 20, or, okay, we've come down now to, 14 or 10. The other way to look at it is that 10 is still a large number of people who are coming in from away, who are on vacation, who are just, so there is that part of 10 that still is going to be very hard to manage and to make sure that the neighborhood can have their peaceful enjoyment of their neighborhood while we're, allowing the rental of this property. So I also think that, and I'm with what Michael was saying, is you drive up, you're thinking, oh yeah, this is more a Tier 3 because it has enough room on either side. And I have to say that I think the new property owner coming in, that it'd be like the others that we looked at where the buildings, the houses are too close for a tier three. It's a lot of people to be trying to meld into a neighborhood.
Thank you, Lauren. My comments come from the ordinance, the first part of it, which says that a permit is not a right. 20.622.010, number 7, talks about the boundaries and TRPA and this and that, but the sentence that I always come back to is, it is the intent of the Lake Tahoe Vacation Home Rental Ordinance to make the transitory lodging activity permitted by this chapter resemble the existing residential uses made by resident owners and lessees. And every time I read that and I hear this kind of outcry from the public, I cannot wrap my head around approving a tier 3 for something like this. So that said, Keith?
Madam Chairperson, I'd like to make a motion. I move that we deny the application for the Tier 3 permit, special use permit, for a 7-bedroom, 14-person occupancy located at 153 Granite Springs, owner IDB Holdings, Louis Sarmiento, at this time.
Thank you. Do I have a second?
Madam Chair, I'd like to second that motion.
I have a motion by Mr. Byer, a second by Mr. Sloan to deny the permit. Any further discussion? Seeing none, I'll take it to a vote. All those in favor of denying the Tier 3 permit signify by saying aye.
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 We have a 4-0 with 1 absent to deny this permit. Would you guys like to take a small break before we move on? Okay, we'll take 10 minutes. We'll be back a few minutes before 3.
Recording stopped.
If everybody could take their seat, we'll get started.
Recording in progress.
We're on agenda item number 3. For possible action, discussion on an application to obtain a Tier 3 vacation home rental special use permit. The subject application is for a 6-bedroom home, 12-person occupancy, located at 750 Lakeview Circle, Zephyr Cove, Nevada. The owner is Robert and Maria Tarn, who currently have a Douglas County issued VHR permit, account number 084000377, APN 1318103120006. Mr. Booth, are you taking this one?
Thank you, Madam Chair. Sam Booth with Community Development. For the record, as you just read, this application is for 12-person occupancy, a 6-bedroom home at 750 Lakeview Circle. On page 113 of your packet, we have our summary sheet here for the property. Total parking approved for the site is 5 spaces. I would point out, I didn't mention on the last one, but one other thing we did here was where we list the insurance policy and insurance company, we're noting that they do have a rental rider on the policy. There's a coverage amount of 1.5 million liability coverage. Towards the bottom of the sheet there, you can see the listing of the adjacent residences and the distances. I would note that adjacent residence number 1 at 752 Lakeview Circle is 30 feet, and at 746 Lakeview Circle would be the second closest at 32 feet. I think the only other thing I would mention at this point is that we do have a condition on this that's become somewhat of a standard condition, that the applicant, if this is deemed to be approved, provide the location of the noise monitors on a site plan for staff's review and approval.
Thank you, Mr. Booth. Let's start with questions for staff or for the fire department. Keith?
Thank you, Madam Chairperson. And this is not a criticism. These things come together over a long period of time. Things change. On page 113, it lists Avi Pakurar as the emergency contact. I think Cecilia, oh, by the way, who does not have a certificate on file, Cecilia Gessa is listed on the permit. But I don't know which person is the emergency contact, and if it's Cecilia Gessa, then I didn't know how far she lived from the unit. Did you follow that?
Yeah.
Do you know which one it is?
I don't know.
Okay,
Look,
sorry,
the
we'll
director's
ask
waving at me. He might or.
Yeah, we'll ask the applicant.
Okay, any other questions on this, Keith?
No, ma'am.
I do.
Lauren?
Yep, one's for the fire department and one is, and I'm sorry, I was not able to go out and do a physical inspection, so, and it's just, and I hope you understand that some of these things are kind of, because it's a new process and we're really trying to get these things together. So one is just a question, and I as a permit holder, it's just kind of like, it's very difficult when we're reading someone's account number. I guess it's more of a question. So we're reading account numbers. We used to have a VHR permit number, but now it seems like we've got account numbers, and I'm not sure if owners should be happy that their account numbers are out there, because a lot of this stuff we're doing where we're saying on file because we don't want to share it. And I really liked where we used to have like a DP number or a VHR number. I don't know why they're different. So I'm just going to throw that out for Tom or Sam. I had a question for the fire department. It's just a question process. Is there a charge for a reinspection?
There can be Chris Roulette with
Tahoe Douglas Fire Department for the record. There can be a charge for a reinspection. It depends on the type of reinspection and the amount of time that's going to be spent doing a reinspection. Some reinspections are done with photos and video of items that need to be corrected. Some don't require a physical reinspection.
Okay, thank you. I was just curious as to, just as far as when we're looking at the fee service of fee amounts and all that kind of stuff. I'm having a problem, of course, with bedroom 6. Although this one I kind of understand it's in a way, but we've got to get clarity on this and what we do with those things. And again, that discussion and that primary purpose was because we didn't want the VHR program to be about cramming people into every nook and cranny in a home, but instead melding within the neighborhood and hopefully finding that wonderful balance between private property rights and the peaceful enjoyment of a home. So I'm really looking forward to the discussion where we can really get to whether that constitutes a bedroom or not. The other question I had was, I'm really hoping that if the fire department, or maybe it's HDL, if we are using the garage for parking spots, that we get a picture of the inside of the garage. I think we had one there where they said they had used the garage, but then on the Airbnb thing, it said the garage is not available. So it'd be nice. I mean, a lot of these people have given a picture of the garage on the inside. Noise monitors, I think you said, because I did see where they were only inside, and I would agree with that. And then I go back again to this assessor's page where it's only a 1-story home, but it has plans for a 2-story. And at some point I will get educated on how there's a discrepancy on that. But it was really more comments, except I guess the only thing out of all that is the designation of bedroom 6.
Thank you, Lauren. I think on the assessor's page, I was looking that up, it says it's a finished basement. And maybe that's the second floor. Michael, did you have some questions?
I have no
comments?
questions at this time.
Thank you. I think I just have questions for the owner, if the owner's here. Mr. Dallaire?
Thank you, Madam Chair. Tom Dallaire for the record. Just answer 2 questions before we turn the time over to the owner. But the account number, Lauren, on these is the HDL account number. We're in the process of entering all of this into Acela. Once Acela gets assigned as being the permitting software, then we will start using this. It'll be a DSTR, short-term rental, because Washoe County utilizes that. They're the parent company, or the parent county on the Acela contract that actually has the contract with Acela, and we're kind of just on the oh my gosh. Yes, thank you. Coattails on. So we're just on their coattails on this account, and so that'll get cleaned up in the next year or so when we start using our software for the permitting. But right now we're using HDL. HDL uses this account number for their TOT. As far as Mr. Byers' question, I had the same question when I was going through this as well with the property manager versus the emergency contact. The emergency contact that they listed was Avi. I think it recently changed, and maybe they can address that when they're doing their presentation. And then the question that we had and the concern was they live in Gardnerville, and it does, if you look at the page 113, when you look at the Google Maps, if depending on which road they take, it is 34 minutes from her location in the Gardnerville Ranchos to get to the site. So I was hoping to have that kind of conversation. I'm glad you found it, and see what kind of direction you guys want. I mean, for us personally and for the code enforcement staff, I think responding to a situation in 30 minutes is what code says, but again, traffic time of day. Most of the time, these guys are going to be calling the individual renting the unit to make sure that they're complying with whatever the complaint is going on at the time. But if they have to make it physically, it is 34 minutes per we use Google Maps in order to determine that time.
Thank you, Mr. Delaire. If the board's ready, I'll have the owners give a presentation or.
I'm good? Okay. Speak a little closer. Okay, in answer to the monitors, that's where I didn't get any clarity. So the agents, a licensed agent, which Cecilia is our contact person, and I listed 3, Ovi's the 3rd. Like I said, I had 3 people I had listed on there. As far as the monitors, there was no instruction on where to put them, so the agent, Tom Sloan, suggested we put one in the 2 living areas, one in the living room, which is adjacent to the social area of the house, and one in that bonus room, which we call it, it's a bedroom. Chris is familiar with it. It's a big 260 square foot, meant to be a bedroom, and we took the pool table out for various reasons. I got tired of marks on my wall with the thing, so we don't have a pool table in there anymore. It's just 2 sets of bunk beds. And why that's beautiful is a lot of people with small children, a parent will sleep down there with a small child, as opposed to disturbing somebody else upstairs. And that's why it's attractive. I actually keep in contact with all our neighbors, and there are only 2 full-time neighbors on our street, and one's right next to us. And the owner is lovely, and we get along. I have an email from her that she has no problem with us being a vacation rental owner, and her tenant has never been bothered or harassed by any of our tenants. And I also went to meet the tenant because I thought that was important, and he said we do a great job. He's never even heard noise coming from our house. And as far as the garage, I did send pictures of the empty garage that's available. I don't know if it ever made it to you, because that was asked for, and I did send it. And I can send it again when I get home. It is available. We have 5 parking places, 2 in the garage, 3 on our property. I actually am proactive on the trash. Because of our house sleeping so many people, it garners a lot of trash. The first thing people do is go to Costco and buy way too much food. Our housekeeper's fed for a year, but the trash they accumulate. I hire somebody and I pay Eduardo $50 a pop to take, not only take the trash from inside our garage, but to clean out the bins so that there's no smell. That's very important because if it gets really grassy, that attracts bears. And so we don't even use our bear box, and I let our neighbor use it because she has a long-term tenant in there, and she doesn't have a bear box. She put hers on our property, and we years ago laughed about it, but she gave up vacation rental. It was too hard for her. So she has a long-term tenant in there, and she's great. She sent me an email, said we've never been bothered or harassed. The other long-term tenant is farther up the street, and a lovely man, and he's never had any complaints. And I think after 20 or 30 years of doing this, it's a good partnership with the people that work for me. We treat them well, we pay them well, and they feel like it's their house. And that's why I was...
Can I jump in? 28 years.
Sorry.
28 years.
That's why I think it's important, if we own the house, we have vested interest in it, to know the neighborhood, to know the tenants, and having an agent who's not going to do it. When I hear a tenant and they sound debatable, and after doing this for a long time, like they said, oh, by the way, we have a dog and we have no pet policy. I'm sorry, this is not a pet-friendly area. We don't have gated yard, we have hardwood floors, and they cancel usually. So I think that's really important. Tom's willing to go on board. I'm going to be paying him $4,200 a year just to be tied on the thing. He said, if I need him, should I ever need him, I'm going to pay him $150 an hour to call somebody out and take care of anything. So that makes Cecilia a moot point because he's less than 2 miles from our house.
Thank
and I don't know if we have any neighbors. I don't think any neighbor would call and complain the only one neighbor I talked to this morning said he's fine.
So the bear bin that's in the asphalt belongs to you?
It's on our
but
property.
The neighbor uses it?
Yes, it's on our property.
And it has the signage that says...
I let him do that because I don't want our tenants tempted to come out of their car and empty their car out there And he put no parking there because he likes to have, when the trash people come, to have it available. They still park there,
Okay.
and he lets them. But I
Okay.
asked the tenants not to park there on Tuesday nights. Monday nights, because they come early Tuesday.
That was very confusing because.
I know, and the poor lady,
The
when she put.
picture, I'm looking at the picture, when they gave us the next door neighbor's bear bin picture.
Our property line goes past that to that rock, and she just bought the house, and she wanted to put it in, but she didn't want it close to her house. And so she thought, okay, I'll put it here. And then I said, Ava, that's very nice, but it's on our property. She said, oh my gosh. And she didn't live there, so she said, oh, I'm really sorry.
Okay.
And then it got to be like this. And I
Okay.
said, yeah, I don't care.
Okay. Who has questions? Keith?
So, and I guess maybe this is to Sam or Tom, the emergency contact. If I have a problem with the VHR, I can find that emergency contact, or if I'm the next door neighbor and there's a noise complaint, is that accessible? I'm sorry,
I'm sorry, go ahead.
I'll come back to you in a second.
Okay, I'm sorry.
That emergency contact is a public document that I should be able to find and call? Emergency contact, the emergency contact?
Yeah, Tom Delaire for the record. It is. It's on both the search from, you can get onto HDLs. We have links on our website for that. And then also our online viewer. So if you Google Douglas County, Nevada's GIS, go to the vacation home rental public viewer, you click on the property that you're inquiring about, and it shows up in a table and has that number.
Okay, so thank you very much. And I really, just clarification questions. Oh, by the way, FYI, I think I know the neighbor you're talking about because.
Larry?
I don't know, he was removing snow. Unfortunately, when you're driving around looking at these things, a lot of people wonder what you're doing in their neighborhood. And he was shoveling snow, and I'm looking, and he's like looking after your property, so I was telling him thank you. And I'm like, no, I'm here doing this, just looking. And he said, can't tell they're ever there. No complaints whatsoever.
Oh, thanks.
And so I'm pretty sure that's the same person because he is a renter. So I think that's who you're talking about. So but let's say that someone has a complaint, because my concern is he's the opposite side of your big deck. And so if somebody looks on that system, are they going to see Cecilia Gasso?
Well, that's on my permit, so I'm not sure what they put on that system. I noticed on that map you have where you have little dots, it has Cecilia on it.
Okay, and where is Cecilia's address? Where would she live that would respond to a
I don't know.
complaint?
She's on-
Because that's who they would call, not, I know you
Yeah,
have
it's a
three people.
530 number. She's in Carson. So I think that Gardnerville address, Tom, that you did, was that Ovi's or was that Cecilia's?
That was Obi, I think.
Yeah, and Ovi's the third contact. He's always working, he's building some houses at Cave Rock, so he's around.
Sorry, she's,
Cecilia's not the address he Googled 34 minutes.
okay.
That was Ovi.
And so I guess my concern is, and I hear what Tom's saying, 34 minutes is awfully close to 30, but so is 35 and
No, but
36.
I'm just pointing out the address he Googled was the wrong person.
Okay, but it was Carson City.
He's the third one.
Yeah, so what is do you know the physical
Let me
address?
get my phone, I can tell you.
Okay.
I also have Tom, which is 2 miles away, the new agent.
Yeah, but I guess I'm more worried about someone having a complaint.
Oh,
So,
yeah.
from
I
your
get it.
perspective, I see you got 3 people you can call. And by the way,
do.
35 is close.
No,
But
no,
I
I
guess
get
I'm more
it.
interested if somebody has a problem and they're trying to take care of it without calling the police, without
No, I
following
get it.
reports, they're going to pick
And we want you
Cecilia.
to know, although I know the ordinance has a specific requirement, and we got to meet that.
Yeah.
But we've been doing this for 28 years, and we've always given our cell phone number to all of our neighbors.
So do you want
And
the address,
whenever there
Tom?
has been an issue,
Yes.
their first call's been to us, our call's to the house, quiet them down. That's the way we take care of things. We mitigate things that way.
Okay. Because, like I said, I do start off with this one kind of nervous about the proximity, and especially with that relatively big deck, very close to them. But I think we'll hear in public comments if there. But so, are you going to ask about the bear box? I think I'm done.
I was going to let Tom work on whatever the question was, and we'll ask some other questions.
Okay,
so
I'm
he
done
can,
then, thank you.
Some do that. So there is a property manager, but it sounds like it's a similar situation to the previous person who had a...
Yeah, but he's available at $150 an hour if I need him. If I have an emergency call, I call him, or Cecilia will, and he has people in his office, the
Okay.
Sierra Realty. They're at Round Hill.
Okay.
That's the deal I worked, I pay him that.
Right,
monthly
right,
fee.
so there is a property
Yeah,
manager.
yeah.
And he's, that office is 5 minutes away.
Yeah.
Right. And,
I think I gave them the information, and he signed a letter of agreement. I have not signed the contract yet because I wasn't sure I was gonna get my permit, and I didn't want to be bound to be paying him unless I got it.
yeah. Okay, Michael?
Okay, so first, for just open clarity, this property manager, Tom Sloan, is no relationship to me. I don't know that
No,
person.
you won't get a cut of his money.
Yes. So wanted to bring that up, and I wanted to, before I start with a couple questions, I wanted to really thank staff on a couple things where they, on the insurance company, they put down that they're a Nevada company. Really think that was helpful. And then on the adjacent residents, for them to list that, who the VHRs were this time, really, I think helped out me, and I think helped out other board members to see, just who's around, because before all we would get is 5 different properties, and we just didn't know if they were VHRs or what they were, so that was really helpful. Seemed like a very active owner and wanting to do good. I just have a question on the, just the closeness of them, they're 30 feet on one, 32 on the other. The board has, had to deal with that in the past. Why do you think, having 14 would be better than just a tier 2 10?
We're okay with 12.
12, I
Okay,
mean,
yeah, we're okay with
yes,
12. Because that bonus room, I can't tell you how many parents told me when they have a young child to be able to sleep. The bottom of one of the bunks is a double.
Yeah.
So they can have their child upstairs. So if you have a child under 4 years old, I don't think I would want them sleeping in a room by themselves in a strange house. So people have told me that either the father or both of them sleep in that bottom, and then they let the little child sleep up front. And that's why. We have queen beds in the other bedrooms that isn't conducive to that.
Okay. And then I had a question. This is on page 138 of our agenda packet. It's a photo you provided, shows the box, the bear box, and then behind it, it kind of shows the snow, and I think there's one car in it. I'm trying to get to it fast. And so my question to you is, it looks like, and looks like the picture was taken long after a big snowstorm. So how do you keep that driveway clear? I know that's not easy on where your location is, and it looked like it would be very hard to get 3 cars sideways in that driveway as it sits right there.
Believe it or not, Cecilia takes it upon herself to clear that when a tenant's coming in. She clears that, she clears the deck, and she clears the driveway into our driveway.
Okay. But it just wasn't cleared when you...
I wouldn't want to do that job, but she does it. I used to have a snow removal person. She asked if she could take it over because she wanted the extra money. I said, I don't care.
Okay. So in the December storm, she was able to keep it clear?
She was shoveling, her and her son.
Okay. Yeah, it just looks, when we drove up, I think you actually came outside and posted your notice.
No, that was the housekeeper.
That was the
Cecilia.
housekeeper,
She took
okay.
it down because it was
Okay.
falling off, and I
All
said,
right.
no, Cecilia, you got to put
Okay.
it back. It was the
So
same
when we
day.
came up, the driveway looks like it would be fine in the summer.
Yeah.
It just looked like in the winter with that snow and that location, I'm not,
She
it's
does a
tough
good-
up there
she does a
to
great
keep it
job.
clean. And let's see.
And we also have snow shovels in the driveway and in the garage, we make sure, so that if a snowstorm overnight, they're able to shovel out. And I tell them to let me know, and Cecilia will go up there and clear.
Okay. And just so that I'm clear, I got a little confused on that bear box. It's your bear box, but you don't use it, she uses it.
The neighbor, yes.
The neighbor,
The
the
tenant,
neighbor
yeah.
at 146
Tom, yeah.
uses it.
Yeah,
Okay.
Larry.
All right. Okay, thank you.
You're welcome.
Thank you, Michael. Lauren, do you have any comments?
It's difficult because this one is close and I wasn't able to do a physical, so I'm gonna have to rely on you guys with that. I think that the understanding of the responsibility of keeping the VHR and not disturbing neighbors is definitely there. I understand you took the pool table out, but this is what we have not yet gotten clarification on, is to whether couches and tables and chairs are also not a primary use. It's more like a half living room, half bedroom. And I know we just have to get more clarification once we get to the ordinance. So unfortunately, you're just kind of in a gray area right now. I'm kind of asking the board, we had another similar one that was close. And I think we gave them a year to come back and see how things went. Do I remember that? It was kind of, I think, the first meeting we had. I don't know, Mickey, if you can fill me in if we've done that, if we did that.
Yes, in Round Hill, we had one across the street, I think, from the other. And one of them we approved and one of them we did not approve, because the approved one, the owners lived on that street nearby. So we gave them a conditional approval, as I recall. I'm like you, though, with them being so close together. I know there's no complaints, but people do buy and sell property and things could change. So yes, we've given to answer your question, yes. Do you have any other questions for the owner?
Just to answer her question about that room, we could easily, and I've talked to Chris about this, just add a wall there, and that could be the room, and then that'd be just a bonus room with the TV but I don't see the need to do that, because they call it the kids' suite, because the wall our house has the entrance to it, and then to the left when you walk in that room are the bunk beds, so we could easily put a wall and a door there. But it's just much more fun for the kids to see the TV when they're laying in the bunk bed, or if they're going to play a game together, to have it open. It's
So
just
that
a unique
room,
situation, and that actually faces Forest Service below us. It's where the snowmobiles are parked for Zephyr Cove, so it doesn't disturb that room, is like below level. That was the basement that was built out when we bought the house. It was that way.
Lauren?
And on the other side of that.
So I just want to clarify.
Sorry.
I just wanted to add on, so right behind us is there's an open lot, 3 acres. And that room is on the lower level, so it's down below the slope. And it's pretty isolated from the neighbors in their living area. And behind that lot that's behind us is US Highway 50, which I think generates more noise than anything.
Lauren?
I just wanted to, I understand what they're saying, and this is something we're gonna have to address, and it's just the fact that it's the fact that when that came through and became part of the ordinance, it was a question of there are many places that try to multi-purpose a room to be able to put people into every nook and cranny. And the question was, is that the process we want to have, or is the process we want to have more reflective? Your next door neighbor sounds like there's one person who lives there. We're never going to get the same parity between a VHR occupancy and what the occupancy is of the neighborhood. We'll never get there. But the question comes in is, where is that sweet spot between property rights and renting and the peaceful enjoyment of a home? And I'm not saying in this case, but what I'm trying to do is just clarify for you that the owners there as to what we're talking about. And so the thought was, when that became part of the ordinance, that a room is either a living room where they sit and then they play games and they watch it, or it's bedroom and maybe there's a TV, but there's just a bed and TV. And that then kind of stopped that process of cramming people into every little part. This is a beautiful place, and it's not yours. I just wanted to explain that part. Thanks.
Just to mention, the house is about 2,400 square feet, so there's plenty of room elsewhere to gather. It's not like that's the only place to gather. It's just the kids' area. I know what you're saying, too.
So Is it similar to like a master bedroom suite where you'd have a sitting area and a bedroom and a bathroom or whatever you'd have? Okay.
That room is 260 square feet, which is 2.5 times the size of the typical bedroom.
Okay.
And it has 2 sets of bunk beds against the walls. That's a game table on that side, and then it has a couch, and an overstuffed chair, and a TV on the other side. Other end of the room.
So there's not a game,
No, the
the
pool
billiards
table's
The
table
pool
is
table
gone.
came out, there's a game
It's
table.
a portable.
Oh,
card
you mean
table.
like a poker
Card
table
table,
or a
poker
card
table.
table? Okay.
That's what it
Okay,
is.
thank you. Keith?
Well, I guess I'm still a little concerned just about, because my recollection of the past was we were saying the regulation is a regulation. And so I absolutely get this is a massive room. It doesn't look like you turned something in, there, but I'm assuming there's a TV and on page 133 in this room, there's a picture. There's 2 couches. There is a chair and there's a pool table. The pool table is now a card table.
No, it's gone, yeah, that's just.
So I guess my concern is if I was staying here, this is where the kids would congregate and watch TV and play cards, or adults play cards. And so I guess I'm coming back to just the strict ruling of the regulation. It's meant to sleep. I don't know, like I said, it is a difficult call. I would probably go along with the majority, whether this is a bedroom or not. I'll kind of defer to you guys. I can see this both ways. But I would like to know what I don't know if we have any comment. I don't know if the other neighbor who's closer to the deck is there.
They're not. They live in Orange County, California. It's an older lady, and she lets her adult children who live in the Bay Area just use the house as they
Okay,
feel
so
like
it's almost not a
It's almost
vacation
a
rental, but
vacant
it's
house. Yeah, right.
it's not a permanent residence. I am concerned about the noise, and maybe there's noise, maybe there's no complaint. I mean, just reversing your sentence, maybe there's no noise complaints because there's nobody there. Where someone else could buy that house and all of a sudden hear a lot of complaints. This is one of them that we didn't have noise monitors. We now have technology which could answer this question. So I also want to point out that we have in the past approved for a year, subject to them coming back with the noise monitor data. If there's a lot of noise on that deck, I mean, let me just be blunt. If there's a lot of noise on that deck, but we're not getting complaints because no one lives next door, even though there's a house there, I'm more concerned. And you did mention that your agent told you where to put the noise monitors, and I
I called
agree.
and asked the county, and they said they had no idea.
Yeah, and so, and I agree, and I got no idea. But if I was gonna tell you we're putting noise monitors, it's on that deck. Because I think that's the most likely place to cause noise that's gonna affect your next door neighbor
Yeah,
when their windows are open.
Yeah, we can move it there. One of the problems we have is our internet. It's based on the internet. We have a lot of problems with our internet. In fact, they've been out 3 times this week. It goes in and out there, especially if there's an electrical surge.
Yep.
And our internet's down, I have to wait for them to come. But we did, and I get an email if it gets past the 70 decibels. But we will move it to the deck. That's easy enough to do, but I'm not sure.
Okay,
I'm glad to do that. And then we have one in that big kids' room.
yeah, okay, thank you.
You're welcome.
Thank you, Keith. Michael, do you have anything? This one is a struggle for me. I know the neighborhood very well because I live across the highway from you.
Oh, you do? The lodge?
And I know it's a narrow road, and I know with the 2 other VHRs, there's a lot of cars up there. And it worries me from a standpoint of safety. Yet there's no, you don't have a lot of neighbors. So I think at this time, if everybody's good with this, I would like to call for public comment so that we can see what's out there. And then if we have some more questions, we'll call you back up. Thank you.
Dale Roberts. this brought to mind when you're talking earlier about saying, well, the rules are the rules, and this is the ordinance, and this is how it goes. And so I'm going to interject on this here, where obviously this VCR, or you get it, but VHR has one bedroom with a bunk that has a single on top and a double on the bottom. So obviously this bedroom's intended to sleep more than 2 people, which is the ordinance. And then the other bedroom, which they're talking about, that seems to be multi-purpose, has 2 bunk beds in it, which is meant to sleep 4 people, which is obviously, once again, beyond what the ordinance provides for. So that's something I think you really need to evaluate when you come up with your decision as to whether or not you're going to approve of making this happen or not. And I would think that maybe give it a year, see what happens, until you actually review it and do it again. Thank you.
Thank you. Let me finish public comment. Ellie?
Hi, Ellie Wallow, thank you. I do have concern about the emergency contact and the revolving 3 people. In code, it says being available 24 hours by phone in case of complaints. And I'm glad there's property managers. I don't know if he wants to be called at 2 in the morning if you can't get a hold of your other people. I also have winter seasonal concerns of, I mean, we can say it's 34 minutes. We know how Kingsbury grade has its issues, just like every grade in the access to the basin from down here. So I do have some concerns about where the emergency person is actually going to be located. So that's something just to take in consideration when looking at this. I also just look at the pictures. I don't drive by these places. Staff has done a great job where I don't feel like I need to go look. There's enough content. We keep adding more content to the packets. Again, this is a process and evolution, but the one where the snow wasn't removed, and if it snows and somebody has to move a car, where does the car go until snow can be removed? There's 2 diagrams, I'm just being nitpicky, about where the trash is in the garage. It's great that it's in the garage if that's the way this is going to work for them. And it sounds like whoever is the contact person is the one removing the trash. There wasn't much clarity on that. And as we get into definitions of bedrooms, I mean, it used to be you had to have a closet. These larger rooms that are being converted to cram people into, I'm not saying at least most bedrooms by standard have a closet of sorts. Some people choose when they build new houses to put in armoires. I'm not trying to get away from this. Again, we will work the process through the fire department as this is an evolution, and I want to thank the fire people, the police, everybody that's involved in this evolving process. Thank you.
Thank you, Ellie. Any other public comment from the chambers here? Ms. Reno, do you have anything online?
Thank you, Madam Chair. Ann Reno. There are no Zoom comments at this time.
Okay, then I'm going to close public comment, bring it back to the board. I think, Mr. Tarn, did you wanted to make you want to respond?
I just want to make sure there's clarity on the bedrooms. The upper level, which is at street level, has 3 bedrooms with queen beds. The lower level has 2 bedrooms with queen beds, and then the larger bedroom that has 2 sets of bunk beds.
Thank you.
Okay.
Mr. Booth?
Oh, just one more thing too, on something she said.
Just very quickly, Madam Chair, Sam Booth, I just wanted to clarify for the record that Cecilia, the emergency contact or one of the emergency contacts, the address that Maria gave me is 3001 Orvado Drive in Carson. From Google Maps here, it's 29 minutes to the residence. So,
I got it by the skin of my teeth, huh? Thank you. On that trash issue, it's a different person. It's a man, because he cleans it out and takes it out. And he's there the same day somebody checks out, or if nobody's checking in, then he comes the next morning. And like I said, he cleans out the trash bags and puts disinfectant in it. It's too much work to expect Cecile to lug all that trash. And if you want to know where he takes it down to Genoa, he lives in Genoa, and I guess there's a dump near there. Okay, and then as far as that day you came by, that was a checkout, and she was shoveling, because I remember that day, and it was a lot of snow, because she said they were there for 4 hours doing the deck, the driveway, in front of that. Thank you.
Thank you. This trash thing's getting more confusing with every meeting. Because this home does not have trash service, but they have a private person that takes their trash, I assume, to the trash.
So Genoa, he lives in Genoa, and he takes it down to Carson. He can take it to South Refuse.
Oh, okay, so he takes it to Carson, okay. Lauren, I always depend on you to ask that question. Do you have any comments to make?
I guess my only, I mean, I know we're working on the process to get something signed where the owner signs an affidavit saying that their employees and anyone who touches trash from a VHR will take the garbage to X spot, and that they've notified them that no illegal dumping can happen. I know we're working there, so I was just being quiet with it, knowing that we are working towards that process.
Okay. We get back to this bedroom again that we defined previously as not a bedroom when it came to us, when there was a wet bar and a game table and that kind of thing. And I feel like consistency is really important for us as we go through this process, all of us, of learning how to manage to live together and play in the sandbox. So I'm going to ask the board, how they would like to go forward. Lauren?
So, yeah, I mean, I'm having a hard time too. I mean, I remember, why that was put in. I think I really would like to talk about this with the group and get some better clarity on it. But even if we get better clarity on it, to me, the choice is a bedroom or a sitting room, living area. It's not one or the other. Now, that doesn't mean that they can't leave. Let me ask the group this. To me, it doesn't mean that they can't leave it this way, but they just can't get occupancy for that area. They can leave it this way so that there's more sleeping options, but there's only then 5 bedrooms, so it'd be 12. That's my understanding of it. So if they want to have more sleeping options, but you just can't get the occupancy for the multi-purpose room.
5 bedrooms would be 10.
10 plus 2.
No, 2. With the new ordinance, if it goes through, that only goes up to 4 bedrooms, 4 plus 2. So a 4-bedroom and a 5-bedroom effectively are 10 occupancy. And I'm sorry to do this to you because I know you're remote and.
Yeah.
But I don't want the public to be misled.
Okay.
Thank you, Madam Chair. I think if it's the permit application we were thinking of, this was the one that had no bed in the downstairs room. It had a pull-out sofa sleeper and furniture. And so that's why we said, hey, there's no beds in a bedroom. So that's why I think, eventually the board did not approve it. So this one, I believe, has beds, right? Okay, so slight difference.
Yes, you are correct. That one did not have beds, and we spent a great deal of time talking about should they put in a bed or a nightstand or whatever. It's subjective at best right now with this one. Does anyone want to make a motion? You will?
Yeah, I have a comment.
Oh, Michael has a comment, okay.
Okay, so this is really difficult now. Look you straight in the face. You're the epitome of a VHR owner, believe me. I have to be consistent with my own feelings and what I believe is a pure Tier 3. And having neighbors that close, in my opinion only, is not what the county commissioners thought would be a pure Tier 3. You're terrific owners, but I'm against a Tier 3 only because, not because you're the owners, only because of the closeness. Thank you.
Thank you, Michael. Keith, anything?
I hear what you say, Michael, about the bedroom, and that this really does have beds in it. It's not furniture you sit on that becomes something you sleep on at night. Futon is not a bed. I sense that, but it is the rule. I can't say it's not our job to interpret rules, but to me, I guess I'm leaning to the rule saying it's primarily a bedroom, and I look at this and there's a card table. In other words, when we took the pool table out, there's more room, put a card table in. And so I think we're all getting to the same outcome, but just for different reasons, which I don't think necessarily is bad. I think you may not want to approve it because it's a 30 person. I am nervous. I'm nervous about that too. I think I would be a little bit, I would be more comfortable granting, but making them come back in a year, but then I'm probably a no on the bedroom. So I think we're both no, but for different reasons. Now they mentioned they may build a wall. And so if they built a wall, they may get my vote, but still lose yours if they came back with noise. In other words, if they came back and said, the people we rent to were such good screeners that this deck never causes a problem, I could probably be convinced if they built a wall in the bedroom and did that, I could be convinced in a year from now, but I'm probably a no right now, but we're just for different reasons. And I think we need to be unified on our decision, not the reasons.
Thank you, Keith. Lauren?
I mean, just because I need the clarity on the bedroom, and because to me, we set precedents, and until we get that clarified, to me, I'm kind of a hard line on the bedroom. And Mickey, you blew me away with the 4 and 5 are the exact same. So I'm not exactly sure, but I do feel that these owners do understand the responsibilities and try very hard. And I believe that they're kind of like the people that we had before, where, I mean, if you give a year and you ask them to come back and we see how things are, but I also understand it's close. So I'm kind of a no on the bedroom, but I am thinking along the lines of the fact, I think maybe Keith said it, where, you give it a year trial and see how that goes.
May I ask a point of order? There's 4 of us. Is 2-2 not approval or denial?
Yeah, and it would draw, and a draw is a non-action. This is Sam Taylor, by the way, Douglas County DAs. So it would not be an approval of the Tier 3 SUP. You have to have an affirmative vote, so 3 would need to vote in favor.
Thank you, Mr. Taylor. This one's really a tough one. Does anyone want to make a motion? The problem is you seem like wonderful people who are very responsible, yet the precedent of what we did previously is in my head. The 30 feet or whatever is in my head because we've talked about that at every meeting, that we feel it's too close. So I don't know where we need to make a decision. So
can I ask a theoretical question to each of the members? There are remediatable things and unremediatable things. I don't think anyone's going to move that house further away, right? This room can be remediated. They can remove the furniture. They could make it a separate room. So if we were to separate these two issues and say, would you approve being 30 feet away, subject to coming back next year with noise monitoring data? Could we condition a permit to say they will fix this room issue? Because they could do that, but we still have the outstanding closeness issue. Where would we be there? And maybe we could work backwards. If there's a majority who, if they remediate the room issue, if there's a majority there, then we could remediate, we could do that. We could ask them to remediate and come back in a year. Or if we're all saying 30 feet is just too close, because I am absolutely with you. When the county commissioners talked about a tier 3, the people who changed their mind said, I don't have a neighbor anywhere near me. I couldn't cause a problem if I tried. There could be a problem without much trying here because of the 30 feet. I've gone back and forth and back and forth. I'm uncomfortable with 30 feet, even with noise monitoring, because the people could change. And so I guess I'm coming to your line of thinking. It's just too close. And so I would say that you can't remediate the other house. And so I'm probably a no. But I think all of us are struggling with this one, because I would love to approve this. I just can't get past 30 feet could be annoying. You don't even need a lot of people on that deck to cause problems for the neighbor who's just not there. And I think we're talking about property, not who happens to be there.
Thank you, Keith. Do I have a motion?
I'll make a motion. And I don't like making this motion, but I'm going to. I'd like to propose a motion that we deny the permit for Tier 3 at 750 Lakeview Circle and Zephyr Cove.
I second.
Okay, I have a motion and a second to deny this Tier 3 permit. Any further discussion? Just say no. Any further discussion, anything? Okay, all those in favor of denying this permit signify by saying aye.
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 Let me finish. Okay, there's any nays, no nays, so the permit is denied 4-0 with 1 absent. I don't think we need any more.
It's up to you, ma'am.
What's?
It's up to you, whether or not you want to respond.
Okay. Oh, okay. You can work this out with staff, but you get.
You can't be noisy.
Well, just to,
No.
Okay, and the last question I asked, I paid $1,800, so I get to do that back? No. It's a charity?
I'm not involved in that part. Yeah.
I can talk to you out in the hall.
Yeah, thank you. And I think staff is great. It would just be nice to get the right answer.
I understand. Thank you. Okay, agenda item number 4. For possible action, discussion on a special use permit application to obtain a Tier 3 vacation home rental permit. The subject application is for a 7-bedroom home, 14-person occupancy located at 206 South Benjamin Drive. The owner is Tahoe Blue Lodge LLC, Natasha Hughes, who currently has a Douglas County issued VHR permit, account number 084011786, APN 1319193110003. Mr. Booth?
Thank you, Madam Chair. Sam Booth with Community Development. For the record, as you mentioned, agenda item number 4 today is for a 7-bedroom home, 14-person occupancy at 206 South Benjamin Drive. If you will see at page 156 in your packet is our summary sheet of the application. I would note that due to constraints with the width and length of the driveway and allowing the 6-foot access for emergency access to the home, as staff has reviewed the application, we've suggested reducing the parking to 3. Other things I would note there, as far as complaints, you can see that staff has noted that there have been no complaints with the sheriff's office or code enforcement department. And the closest residence would be adjacent residence number 5. It's 695 Amy Court, which is 93 feet away. Let's see if I had any other notes. I believe on this one, we also have the condition, if there's a motion to approve, to include a condition for noise monitors to be included on the site plan.
Thank you, Mr. Booth. Questions for staff or the fire department? Michael?
Okay. Mr. Fire Department, hello. Doesn't Chris look good in those glasses? Okay. Yeah. Do you want to look at and review it, and then I go on to another question? Okay. Okay. So, in your opinion, county is recommending going to 3, and I presume that's 2 in the garage and 1 in the driveway. And so I believe there's some dimensions they gave. What was it? Yeah, 22 feet wide and 34 feet long is what they put in with, and no 6-foot access. That's on page 156. Yeah, I'll give you time.
Chris Roulette, Tahoe Douglas Fire for the record. They have a good picture of that. I think what you're trying to relate to on page 173, with the 3 cars in the driveway. Is that what you're referring to?
Well, yeah, they gave with your permission, Madam Chair, they gave the dimensions, and it's just not the dimensions that are needed, I guess, for parking. 173. So, Sam, I apologize, you were busy. When you recommended 3, are you recommending 3 total, 2 in the garage and 1 in the driveway, or are you recommending 3 in the driveway and 2 in the garage, or for 5?
Thanks. I'd be happy to clarify. Yeah, we are recommending 2 in the garage, 1 in the driveway.
1 in the driveway.
And if you look at that site plan on page 173, the reason being, number 1, the 20-foot width, and then so to park 2 cars next to each other and still be able to maintain that 6-foot emergency path to the door would be an issue with 2 cars next to each other. And then stacked front to back, the issue is that it's only 34 feet in length front to back. And if you have a typical space is 20 feet, 9 by 20 or 10 by 20. And so there's not space there for 2 cars to be pointed front to back. However, I believe the applicant wants to speak to this and believes there's a little discrepancy between the site plan and where the length they have in the driveway to the right-of-way.
Thank you. Yeah, we'll let the applicant speak on that.
Thank you, Mr. Booth. So 3 total is the parking that the county's recommending. Is that right? 3 total, including the garage?
That's correct.
Okay, because this was kind of confusing. Keith, did you have some questions?
Yes, ma'am, thank you. And just to clarify the new rule, because again, these approvals are not, they're for in perpetuity. Under the new regulation, because they are not using 2 per bedroom plus 2, they would not trigger into the 3 cars times 4 is 12. Is that correct?
That's correct, as I understand it.
Yeah, so they would still be 14 even though they had only had 3 spots.
Right,
Okay,
correct.
thank you, sir.
I would just note, Mr. Byer, that there's a finding for that, though. However, in the board's purview, let me see if I have it here in the staff report. There's a finding that the board needs to make that there's ample parking for the occupancy of the unit.
And my next question is it the emergency contact is Janet Martell, physical address, Zephyr Cove, Nevada, 310 Dorla Court. That is a business, I believe. That's her place of business. Okay, is that your place of business?
Yes, my broker's business.
Okay.
I live 2 minutes away.
That was my next, so the person you would actually call in the middle of the night is 2 minutes away from there, so that you're still well within the 30.
I am 2 minutes away. I would be the person.
You're Janet.
I'm Janet.
Okay, great. Thank you.
I think I can explain there. Mr. Byer, Sam Booth, again for the record. So Ryan and Natasha are both listed on the LLC for Tahoe Blue Lodge as owners of the LLC. However, Natasha is listed with the LLC as the principal designee. So we've placed the permit in Natasha's name and the references and everything today.
Mr. Booth, I do have a question about that because when I checked like the Secretary of State's office, Natasha's name came up, but not Ryan's anywhere. But the permit's issued to Ryan and Natasha. So I wasn't sure where Ryan is located in any documents as an owner or a managing partner of this LLC.
Okay, thank you, Madam Chair. Sam Booth, again for the record. I believe that's a combination potentially between the application and the way that they submitted the application with Ryan and Natasha listed and the previous permit. I think this also had a previous permit and the way that's carried over. However, as we reviewed the LLC information, we confirmed that Natasha's the principal of the LLC, and it's right that Natasha would be listed on the permit. So the permit can be amended just to be held with Natasha.
Thank you. Lauren, do you have any questions for staff on this? You're muted. You're muted.
Unmute, I'm sorry. I do not.
Thank you. Keith?
So we just heard, so the emergency contact is not Ryan Kaplan, right? It's Janet. So could we reissue the permit? Because my understanding is this information on this permit is going to go into our database, that if a neighbor has a problem, they're going to pick up the phone and call Ryan, and they should be calling Janet. So could we reissue the permit? Is there any problem with doing that as a paperwork or somehow doing that?
Mr. Delaire?
Yeah, no, after every meeting that you guys do and you make a call or deny or approve the application, we will issue, HDL will send out a brand new one, says this is where you're at. If you weren't approved, then the occupancy is 10, that all the information can be.
I'm sorry, if we did approve, they would issue a new permit with the, thank you.
Yeah, yep.
Thank you. Michael?
Yeah, I'm still following on that. You know, it's very frustrating when I spend time going through the assessor's office data records and the recorder's office, and then you finally found it on the state. It's just mind-boggling that you don't put all legal names, you know, on especially the recorder's office. But in the future, I'd like to see if we could. I know this is off topic. You know, all the legal names if possible. Thank you.
Thank you, Michael. Looking at my notes. So Janet, you're a property manager, a licensed property manager, right? Okay. That was what I understood.
I'm actually a Nevada community assistant for the
Yes.
last 12 years out there, plus my property management and my sales broker's license.
Very good. Okay. You're representing the owner today?
The owner, Natasha Hughes, is on video.
Oh, okay. So if there's no more questions for staff, should we go to the owner? And if we have some questions for her, let's do that.
Okay. Natasha, if you can hear us, if you could please state your name in full, and then the board will ask questions of you.
Hello. Hi, I'm Natasha Hughes. Can you hear me?
Yes, we can. Thank you.
Okay, Natasha, I'm going to ask the board if they have some questions specifically for you. Keith, let me start with you.
Yes, ma'am. And Natasha, I'm hoping you have the same pack we have, because I can refer to some page numbers. On page 179, there's a picture of bedroom 7. I don't know what you call it, but they're kind of recessed bunk beds into a room. When I go back to page 178, it seems to be a rather large room, 14 by 16. What else is in that bedroom? Why have you made so much space of recessing the beds into a cubby? What else is in that room?
It actually is just the bedroom. So you have the 2 recessed bunk beds. There is a dresser and then a rather large walk-in closet. But no, there's nothing else in there. We've kept it clear per the ordinance to make sure that it was primarily sleeping, and so that's it.
Thank you.
Natasha, did you want to give a statement at all before? I forgot to ask you that before we started questioning you.
Sure, yeah, sorry. I'm not a great public speaker, so.
Well, apparently I'm not either, so.
Yeah, my name's Natasha Hughes. I actually reside out in the Bay Area. So I'm sorry I couldn't be there in person. I'm at home with my kids, and my husband works in law enforcement, so he's never home. But Janet is there. She's our licensed property manager representing us. And I do have 10 years of experience in specifically the sales and marketing side of vacation rentals in Tahoe. And I did spend 4 years managing Tahoe Blue Estate, which I'm sure you guys are all familiar with. And now being the owner and managing member for Tahoe Blue Lodge has been my primary job that I'm doing and putting all my time into it. And yeah, I love the Tahoe area. All my immediate family lives up there. My mother, her husband, my brother, my uncle. So, very, wish I could live there. I love the area.
Thank you. I didn't have a lot of questions on this, which I've already asked staff about. Does anybody else have questions for Natasha? Michael?
I don't know if it was Natasha, but Chris, did you actually get back to us on the parking question with regards to the width and the length? I couldn't recall.
Sorry, Chris, for the record. I thought Sam answered that question for you. So was there another question that wasn't answered?
Maybe a follow-up then. So you saw the dimensions and you saw the picture, and maybe Natasha is going to speak to this or
yes,
the property manager, but maybe I should just have Natasha speak to it first, and then maybe you can listen. Natasha, would you please? I got a line, didn't I? Would you please explain how you think you can get those cars parked?
Yeah, absolutely. So actually, we were going over the agenda packet yesterday, and we're looking at the recommendations and noticed the 34 feet seemed rather small. When we originally had that measured, I had an assistant who went out there to measure it. And we believe that she mistakenly only measured the wooden slatted part of the driveway. We actually, if you look at the photos, do have an asphalted part of the driveway behind that. That adds another 10 feet on. So Janet did bring pictures as well as new dimensions for you guys. If you'd like them, I can also email them over. But essentially, the length of the driveway is actually 44 feet, and that was our mistake completely. So with that, and I think with staying within the ordinance, we could do 2 cars in tandem and still be within the regulations, I believe. So that would kind of be my hope, is that there would be a way to remedy that, or if you guys have any recommendations. I didn't know if I should send that over to the code enforcement officer prior to the meeting, but thought I would just bring it up here as well.
Thank you. So you're suggesting 2 in the driveway, 2 in the garage? Is that what?
Correct. Yeah, with the updated length on it, since there is an extra 10 feet, and we would be happy. I don't know if someone needs to come out and measure. We would be happy to accommodate that, of course.
Thank you.
Madam Chair, Tom Delaire, if I may.
Mr. Delaire?
Yeah, thank you. Natasha, this is Tom Delaire. I actually did the drawing on this when I was reviewing this project. You have a right-of-way as well. It's a public right-of-way. I don't know where your property corners are at actually up there in Tahoe. I didn't get to go up and look at that, but it appears to me that the wood stops at the right-of-way line. And I don't know if you can get the property corners located to get that extra length, but per county code, our parking stalls in Douglas County are 9 foot wide by 20 foot long. So we've been taking the point that if you have 40 feet, you can get a tandem parking in that driveway without using the right of way, I guess is my point. And so if we know where those property corners are at, then of course we can look at that measurement and revise this, but that was based on my recommendation. And if you get 2 Suburbans in there, you're going to be sticking out into the actual right-of-way.
Sure. Yeah, I can definitely look into getting the property corners on that, just to double check it. Thank you.
Thank you, Natasha. Any other questions, Keith?
Yes, ma'am. On page 153, if you look at last year's permit to this year's permit, I think you went from 6 to 7 bedrooms.
Mm-hmm.
Can you, now looking at page 177 and 178, where did that extra bedroom come in?
Yeah, sorry, I'm just trying to scroll through. So it is on the 2nd floor, bedroom number 5. Bedroom 6, which is attached off of that, used to be an owner's closet. It was always a legal bedroom, but was not being used as such. So it is the room that you'll see the twin bunk beds in. So we did utilize that as a bedroom, which is why the permit did change.
Okay, so bedroom 6, last year was just a closet area, but it's massive. And so now you put beds in there and that's the bedroom, correct?
Correct. Yeah, it was always a legal bedroom, but yeah, we just moved all of our owner stuff out of it basically and made it into the bedroom.
Thank you.
Thank you, Keith. Is this the bedroom where you walk through a bedroom to get to a bedroom?
Correct.
Okay. I thought I saw that. Okay, thank you.
Yeah, I recommend, I'm sorry. I was just gonna say, I recommend when I am talking to potential renters that it's like a kid's bedroom, essentially. It's great as a family suite, since bedroom 5 is very large. They both are, but it's great for parents to have that attached bedroom on there. So I try to very much manage expectations for people coming in as to what, is a good idea for that bedroom.
All right, thank you. Michael?
Yes, thank you, Madam Chair. So Natasha answered her question or my question to her on the parking, but I never got it back to Chris. You thought you got off the hook. So my question to you, they're going to look at the length, I guess, for easement, but the width with the 6-foot emergency, what's your thoughts on that? I'm on page, what is it? It's 174, shows 2 cars, 1 truck on the left, a smaller car on the right. And then there's another one that has shows where the 6-foot lane would be, I guess. That's right above it on page 173. Comments?
Sure. Chris Willett for the record. So I'm going to defer to county code on this. I think Tom and Sam did a good job with trying to map that out. And parking is somewhat difficult because you could show up with 2 Suburbans and I could show up with 2 Priuses. And 2 Priuses all have plenty of room to get a stretcher through there. We're not going to do fire operations from a driveway, especially a wood driveway. So if the house was on fire, we're going to be fighting that fire from the street or the hillside, going down or coming around from the other side of that house. So the reason for access would be to get a stretcher through there, if that makes sense.
Thank you, Chris.
Lauren?
I am listening intently and do not have any questions.
Okay, any other questions from here? We can go to public comment. Ellie?
Thanks again, Ellie Waller. Thank you for trying to figure out and identify the parking issues. The fire on a wood driveway never came into my mind. Thank you for that piece of it. I do have another question while I have your attention. When you're evaluating the safety of the home, do you look at, and we don't have a lot of 3rd floor, I don't know the height, I haven't looked at the house. Do you look at evacuation ability of that 3rd floor?
Yes, we do. So, Chris Willett for the record. So, if a bedroom, so when you look at evacuation, you're looking at it from a sleeping standpoint. If you're awake, there's many ways to evacuate. When you're asleep and smoke fills hallways, there's less ways to evacuate. So, we do have a requirement that if it's over 16 feet out that bedroom, that they provide an escape ladder. And that escape ladder's in that bedroom, and if there's multiple bedrooms that are on that level with that there's a ladder for each and every bedroom for escape.
That's a great clarification. Thank you very much. Back to the 2nd floor, looking at bedroom 6 and 5. This is a wonderful master suite, and I don't want to take away from trying to convert closet in, it's probably was a huge closet. I don't know. It looks like there's a window. I don't think that helps clarify for me. There's at least looking at how you enter into the area of bedroom 5. Are you entering bedroom 5 or bedroom 6 through 5? So is it a separate, because it looks like it's a window. I don't know if it's a door. Is it 2 rooms being entered by 1 entrance, as that was a converted closet? Just looking at drawings like this, I'm a visual person. I don't go look at the homes. So I had a question about that. And again, then this sounds like it was a multi-purposed change. We'll get through this. Those are the words. That, let's see, what else did I have on that one? Car size, of course, you never know who's going to show up. 9 feet. Okay, that's it. Thank you.
Thank you, Ellie. Public comment?
Dale Roberts. I first kind of question, well, anyway, the legality of what it was sold for to begin with as a 6-bedroom, because, and then how that transpires into this. When it was up for sale, I went for a walkthrough with the realtor, because we kind of live around a corner, thinking, oh, maybe buy it. And because what does $1 million house look like without a lake view up there? Anyway, the one where they made all the bedrooms was just one monster room with one part sort of curtained off and another part was kind of like this, and they called it 3 bedrooms at the time. as one big room. So it's kind of weird. And how they made it in 7, I don't know. I went by when they were working on it. They were pretty tight-lipped about what they were doing. I never saw a building permit. So I don't know. So that moves into now safety, which that is a blind corner. When you come up Bonnie right there, or not Bonnie, when you come up South Benjamin right there, that's an uphill blind turn corner to the left. When they have all those cars in the driveway, they're backing in and out, maneuvering. I've almost been head-on it 3 times there, maybe 4, because of what's going on. We have called the police because in the wintertime, they back up all the snow on the corner of Amy Court and South Bonnie right there, and it's a huge monster pile of wood, snow, and the people who are staying there, because they cannot fit their 6 Suburbans in the, because everybody drives trucks and everything. I've literally seen it with 6 Suburbans there. They have them, they can't fit in the garage, so they're parked sideways up in that snowbank, which makes that corner even narrower. So I don't know what would happen if a fire truck went by. I'm not going to complain too much about the traffic because the traffic is the issue, because that's a feeder road for Boulder Lodge, okay? So you get a lot of traffic on that road, and everybody's shortcutting coming up, not going up the tramway. They shortcut South Benjamin and cut over and then get the tramway to go to Stagecoach. So you have a lot of traffic on that road going up and down, which adds to the safety feature, because when somebody has their car at the front, now everybody has to back it out and they're blocking the entire road on a blind corner so that person in the front can get out. There's a huge safety issue there. And in the summertime, come on, you got ambulances going up and down. You can't tell me you haven't seen something like this? They go to Boulder and stuff all the time. So you've got a huge safety issue. And then when it's summertime, they park on Amy Court because it's a cul-de-sac, which there's another issue with the house there. Never mind, it only has parking for 1 car. But anyway, so you look at this. Yes, it's 20 feet wide. Now you have the easement. Now our house, we have our posts for our driveway because we also have a bridge that, oh, am I over?
I'm sorry, your 3 minutes has expired. Did you want to finish your sentence?
Okay. Because of the post of the driveway, they're actually in the street by easement. Because just because the street's there doesn't mean that's where the street easement ends. And they need to look at that. So there's not enough room for 6 cars. There's no way.
Thank you. Any other public comment? Oh, there's a race.
So I live at 684 Bonnie Court, and there's several very important issues.
Can you state your name first, please?
Pardon?
Can you state your name?
Oh, I'm sorry, Linda Dangler, 684 Bonnie Court. So it's a canyon that goes up to this house, which is at the end of the canyon. And they've got all these nice big decks. And we're just a stone's throw away, basically, when it comes to sound. And I have called the cops on that house many times, and I can bring you documentation where I called the cops and turned them in for the noise they create for us. It's not very nice to be someone who is a homeowner who bought that home when it was quiet before this fellow bought this house, which he owns the wedding house on the point. And the wedding house is the feeder for this house, so they get these giant parties going on the deck. And it's right there. And they need to have their monitors on the decks, every one of the decks outside facing down the canyon to prove that. The other issue that I keep finding very interesting, and I know you've spoken to it, is that when I look this up at the assessor's office information, the mailing address is the P.O. Box for Steve Kaplan, which is P.O. Box 2342, Tahoe Blue, Steve Kaplan, there's that. And then when I go over to the LLC, the LLC shows, and it's my understanding these are supposed to be all family members living in one house. And especially once we get rid of these LLCs, we've got to find a way to prove who's living in that house and who really has the right to do it. Because I guarantee you that they've got this LLC, which Natasha Hughes, who spoke, is the manager of through a company called Maupin, Cox and Lagoy, okay? Is she related? Is she really a part of this thing? Or is she just the manager, as this said? Because on the application, it called her Tahoe LLC owner. So I think there's a lot of work to do, and I appreciate everything you've done, and much more work to do, because we've got to identify every person who lives in that house, so that when they come up for this thing, and it can't be a friggin' LLC anymore, it's somebody who lives there. And the noise is a huge issue, and I have turned them in. I'll bring you the documentation. And the parking's absurd.
Thank you. So the button needs to get pushed, and so state your name, please.
Okay, can you hear me now? My name is Bernie Hittner. I live at 648 Jack Circle, just around the corner from this particular house. I am going to repeat some of the things that have already been said, but there is definitely a safety issue with respect to this house because it is a blind corner. We come up that road, go past it. We come up that house, go past it, turn right to our house. There have been many occasions where, because of all the cars parked in that driveway, to allow access, some of the cars back out into the street and actually have the street completely blocked. So you come up the street, cars are in the street, completely blocked. And then the other issue is sometimes they protrude out from the driveway, and because it's a blind corner, cars swerve a little wide to get around it, and they can hit the oncoming traffic. And I've had that situation before too. So it is a safety issue. Another issue which was mentioned again is, and if you go on the website, you will see this. This house was primarily purchased to be a feeder house for the house at 650 Tina Court. And that, I know, has been a controversial house. They basically want to run it as a wedding center. It's a house that's at the top of the Kingsbury Canyon, faces the canyon toward the lake. All the noise and music that's generated from that house reverberates through the canyon. 650 Tina Court is owned by Steve and Wendy Kaplan. Natasha is their daughter. And so I'm also concerned that this particular permit may have been procured under false pretenses in an effort to try to get around the one family, one unit home. There are also 3 other adjacent property owners that are opposed to this particular upgrade to tier. They couldn't be here today. They would like to submit a written opposition. So I'd also like to request that this particular hearing be continued so that they have an opportunity to file a written opposition. And I would like to file a written opposition as well so that I can detail the chain of title with respect to this house and show that I think the ownership here is improper. Thank you.
Thank you, sir. Any other public comment in the room?
Thank you, Madam Chair. Yes, we do. Michael, if you can hear me, please state your name in full and your 3 minutes will begin.
This is Michael and Rhonda Hall, and we own the home at 695 Amy Court, which is the most adjacent home to the home in question. And we're simply want to say that we have no issues at all with the permit that's being requested. We're in support of this permit.
Thank you. Any other online?
Madam Chair, there's no other online.
Did you say there was no other? Okay. Okay.
Madam Chair,
Mr. Taylor?
Yeah, Sam Taylor for the record from the Douglas County DA's office. One of the things that I think came up here that I think needs to be addressed by this board, and I would like to sort of highlight the issue here, and it's one of the findings that must be made by this board, is that there's adequate parking. Staff has noted that they believe there are issues with the public right-of-way, which would limit this home to 3 cars, whereas the applicant has noted that they believe the right-of-way extends or isn't as close as what Mr. Delaire had noted previously, and they said it extends 44 feet back from the garage opening. So one of the things I would maybe push upon the board and that you might need to find out is, and it's one of the findings that must be made for this in order to be approved, is there is adequate parking. So you have a big disparity between 6 cars proposed by Natasha and the applicant and 3 cars being proposed by staff. One of the things that I think might be beneficial to the board, and it's just a recommendation, is you can ask Natasha if she'd like to extend this out, would be to allow her to provide some proof that there is 44 feet. Otherwise, I mean, you might be subject to differentiating between the statements made by Natasha and taking her word for it as opposed to Mr. Delaire. So it's just something I'd like to point out for the record.
So, Mr. Taylor, are you suggesting we hold off on a vote until we get this further information?
That is something to consider, yes, Madam Chair. Although the board can most definitely make a decision today based on the information available to it and decide whether or not Mr. Delaire's statement is correct or the applicant's statement is correct.
Thank you. So we could do some kind of a conditional approval or denial. Taking it back to the board, does anybody, Michael, do you have?
Yes, thank you, Madam Chair. So I believe that the board does have the option to request that the applicant go from a occupancy of 14 to 12, which would put 3 cars at 4, which is pretty much the standard, and 3 is about the minimum you would have with if it was a homeowner there or a leasee or, like you say, a VHR. So I would like to ask the owner, if I may, if she'd be willing to go to 12 total occupancy.
Natasha, are you out there?
I'm here.
Okay. Did you hear the question?
I did. Yeah, absolutely. If that's, definitely, we want to comply with the board and, we're more than happy to do that. I also was hoping to just address with the noise, we are very, very aware of it. And we have noise sensors both inside and outside of the home that we're monitoring constantly. Myself, Janet, we're on it. That we've had a long-term ski lease in the home for the last 4 months. And, we take it all very seriously, I guess is what I want to say. So I'm not sure where the noise is coming from, but, we are monitoring it very, very carefully, and we do take it very seriously. Obviously, we want to keep Tahoe, and State Line happy. We want there to be a great relationship between the VHRs and the owners, and, we do everything we can, and we'll continue to do everything we can to keep that relationship, a positive one.
Thank you. Michael?
I have no further questions, but when we get to the point of a motion, I'd be happy to make one.
Poll the rest of the group. Keith?
I am somewhat concerned and torn about noise. We've had, because again, I look at this, the closest house is around 100 feet. So I start with kind of a rebuttable presumption, even though it's a little bit under, that it's okay. And when I drove by it, it seemed okay. However, when you look at the land, because of the way the I don't know if you guys drove around. So when you're looking at that, I don't know if you drove around to the other road. The way the mountain is angled, I am concerned that noise echoes and is funneled down there. I while I hear there may be 3 other people who wanted to come to talk, they were also noticed. And they didn't fulfill that before this meeting. And I don't know how to say that. So, but I guess what I'm saying is I was concerned about noise before, and now we have heard another neighbor complain about noise, several complain about parking. So I'm torn on this one. When I looked at it, it looked okay. I was waiting to hear public comment. I wish the 3 that want to give public comment had addressed their comment before the hearing, but I have heard noise complaints. And when I look at the land, I see why that's possible, if not probable. That is my concern. But I'll listen to motions, and I'd like to hear to me, it wasn't close. Now that I've heard the comments, it is close. So I'd like to hear other members of the board.
Lauren, do you have any comments on this one?
I guess what I'm kind of stuck on is the fact of the parking and just not sure what's there. And so, that one's kind of my my question on getting clarification on that. So, I didn't know if we could, I mean, I heard something different, like we could do something conditional, but can we also just ask for clarification and bring it back to the next meeting?
Yes, we can.
Okay. I'm listening too. I'm with Keith that I'd like to hear, Mickey, your take on it.
I was like you, Keith. I looked at this and went, wow, this is good property for a tier 3. And like you, I'm so disappointed that if there are 3 more homeowners that have objections to this, I think the county makes it fairly easy to send in your comments online. So I was actually quite surprised that we didn't get very much public comment online prior to the meeting to look at, because we weigh public comment very heavily in our decisions. The parking is tricky there. It is on that curve. I actually turned around up there and did find myself gasping. So I do get what you're saying there, and maybe we want to get some clarification, or maybe we want to give a conditional permit. I mean, I think our choices are, we can deny it, we can give some kind of a conditional permit based on the parking and the noise monitors and requiring them to come back in a year, or, we can approve it, but it's up,
Madam Chair, I don't want to make a motion because I think you were, but I mean, where I'm leading is that we defer this to next meeting, and I hate to defer things because next meeting is going to be another one full. My concern of deferring to, my belief of why the deferral is, I would like to know about parking, because again, where there are parking spots, we've all seen where parking spots are not honored. And that is a bad corner. Honestly, now that I've heard public comment, I'd like to see it again. So I'd like to get clarity on how many cars they can park in the driveway. I'd also like to go look at it again, because I never try to turn around on private property. And so it took me a while to get there. I drove by and I looked at it, but my thought was it's 100 feet. I'm not that concerned, but boy, this looks really tricky in here. So I would like to defer it, but if people want to act on it, I think you've offered to reduce the occupancy. So I'm ready to hear your motions, so I don't have to make one.
Thank you, Keith. Michael?
I'd like to make a comment first. So, yeah, we do hear from the public about noise, and that is, we take that very seriously. I think you got that from what happened earlier too. But it looks like, the previous permit was 16. They're asking 14. We're taking them down to 12 and 3 cars. So I think that's pretty much about the bare minimum you can do for for a tier 3. And I would like to just make a motion based upon that and see what the board has to say up or down.
Lauren, do you have any comments on that before I let Michael make his motion? Okay.
Madam Chair, I'd like to make a motion that item number 4, special use permit at 206 South Benjamin Drive be approved for 12 people with only 3 vehicles or cars, and noise monitors be installed per Douglas County.
I would like to see it conditioned on coming back next year.
Madam Chair, what I was planning to do was to second his motion, but to offer an amendment to his motion, that we condition it that the noise monitors include noise logs, that we see noise logs of the actual amount, as I've said before, that it's not based on the number of events, because events are subject to definition, that we get noise logs next year and look at the amount of noise on these decks, that the county work with them to put them on the decks, and that we are able to see the noise created at this house.
So at this time, so that there's not some confusion, maybe, Michael, you could withdraw your motion and make a new motion?
I'd like to withdraw my first motion, Madam Chair, and do a new motion. I'd like to motion that item number 4 be approved for 12 people, 3 cars with noise stations installed and noise logs provided with a 1-year conditional permit at 206 South Benjamin Drive.
I'd like to second that.
Thank you. We have a motion and we have a second. Any further discussion? You did say the 3 cars, right? Mm-hmm. Okay. I was so busy looking at my notes. Any other discussion? Laura, do you have any? Okay. Then I'll take a vote. All those in favor of approving the permit on 206 South Benjamin with all the conditions that are in the motion signify by saying aye.
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 Opposed? None. That would be 4-0 with 1 absent. Thank you. Does anyone need a break, or should we roll on to number 5? I'd like, remember that clock's an hour off.
Madam Chair, if I may.
Yes.
There has been an item that has arisen to my attention that would necessitate, I believe, a non-meeting for the board. I don't know how we do that with Lauren via Zoom. Maybe there's a methodology that we can use a laptop or something and have a private room, but I would like to take that opportunity to have a non-meeting. And it seems likely that this would be a good time to have that.
Thank you. How many minutes do you need?
Well, it depends on the technical aspect. Can we take a laptop with us for Lauren, and then have her disconnected from here so we're not transmitting to the public?
Zoom or on my phone?
Okay, that'd be fine.
Madam Chair, could I ask that we take a 3-minute break, bathroom break before the non-meeting?
Sure.
Absolutely. So what do you think?
Probably 15 minutes,
Okay.
maybe.
So we'll be back at 5 to 5. You guys aren't getting it.
Recording stopped.
Hey, Mickey.
Recording in progress.
Okay, we're going to begin the next part of our meeting. Everybody that was here before is still here. So we're going to agenda item number 5 for possible action, discussion on a special use permit application to obtain a Tier 3 vacation home rental permit. The subject application is for a 6-bedroom home, 12-person occupancy located at 242 South Benjamin Drive. The owner is Jacqueline Castro, who currently has a Douglas County issued VHR permit, account number 08400-791, APN 131919310-001. Mr. Booth.
Thank you, Madam Chair. Sam Booth for the record. Again, as you read, this application is for a 6-bedroom home with 12-person occupancy located at 242 South Benjamin Drive. On page 193 of your packet, you'll see those occupancy and bedroom numbers, that the parking for the site has been designated at 6 spaces, 3 within the garage, 3 within the driveway. Staff has noted that we do not have any record of complaints or issues on file for this address. Towards the bottom of the page there, you can see adjacent residence number 5 at 246 South Benjamin Drive is the closest residence at 67.8 feet away. And other than that, on this application as well, staff is recommending a condition requiring the applicant to submit a site plan showing the existing noise monitors for approval.
Thank you, Mr. Booth. Let's start with questions for staff or the fire department. I know I have one, but I'll let the rest of you, Michael, questions?
Thank you, Madam Chair. So yes, on page 193, you noted all the adjacent residents. And just for clarity, at least two are in a single-family area, and one or two is in a multi-zoned area. And it's one of these unique applications, I believe, that you have a super high concentration of VHRs with 4 of them being a potential Tier 3. So, actually, that was just a comment because I know the answer. The answer is yes. One side of the street is single family and one side is multi-family.
Thank you, Michael. Keith, did you have?
Yes, I guess I'm trying to figure out how we're doing emergency contacts, and again, I had the same question the last one. On page, sorry, let me move my computer. On page 193, we show the emergency contact as Brandon Gerard. I believe the 185 Highway 50 is his office address. Emergencies don't always happen during office hours, and I was thinking that's where the 9 minutes came from. Can we get information on where the person to actually be there in 30 minutes resides instead of the office address? Do you have that information, or should we ask the owners?
Tom Delaire for the record. We should ask the owners.
Okay, thank you very much. I believe that was the only question I had for y'all.
Okay.
Yeah, that's it for the county.
Okay. Lauren? You're muted again.
I don't have anything for the county staff.
Okay, thank you. I have a question for the fire department. On page 204, it says that a monitored fire alarm system will be required next year. What is that about? Because I've never seen that before. If I have, I didn't notice it.
Chris Roulette for the record. So what that is it's a requirement on our end for vacational rentals, and we kind of have different tiers as to why we're requiring that. We want it for, like Lauren Romaine has it for her house. So if your house is a condo, a townhome, it's connected. If a fire starts in that, we want to be able to get there as soon as possible to put that fire out so it doesn't spread and affect your neighbor. In our larger homes, your tier threes or 3 levels or more, we want to require that. So the sooner we can get there to stop a fire and people can get out, the safer it is. So it's a requirement for vacational rentals on our end. So we're trying to give people ample time to get that done. That's why I put it in this inspection and gave them a year to get that done.
Thank you. I just didn't see it in the prior tier threes, so I wasn't sure if it was something brand new. So all tier threes?
Yes, it will be. If it meets the requirements of a tier 3, it does meet those requirements for us. And it has been something that we've been working to, like county code, to smooth out and to get all of the language correct as we implement it.
Thank you. Michael?
Thank you, Madam Chair. So would this be something that the board could actually, discuss and, with the ordinances, that part of the permit process, they have this?
I believe it's fire code, right?
I think if you guys wanted to, Chris Roulette for the record, if you guys wanted to recommend it to the county board of supervisors, you could do that. This is just on the life safety requirement for us, without going to you guys and the county board of supervisors to get that done. We saw an immediate need for life safety, so it's something that we are trying to implement. But by all means, if you want to put in the code, we're not going to stop you.
Add it to your list. Thank you. Any other questions for staff? If not, I'll ask the permit holders, or I assume you're the owner? Okay, to come and speak.
Am I on? Okay.
If you want to give a statement first, and then we'll
Yeah, I'm
ask you some
gonna
questions,
just
that'd be
read
great.
this, and then we can go over some of Tom, for the record's questions. So my name is Jacqueline Castro, and my home is at 242 South Benjamin State Line. Just a little history for you all to understand. This isn't an investment home. This has been in my family for over 50 years. My parents bought the lot, and a few years later after they bought, my dad decided that that's where he wanted to retire, and he built his dream home. Unfortunately, he didn't get to realize his dreams. He passed away in his 50s from cancer, and at that time, my mom decided to rent the house. She rented it for 20 years to Tahoe residents. And then when I had my own family and kids, we decided as a family that we were going to utilize it for our vacations and for our own use. In 2015, my mom died, and she left it to my brother and I. In 2018, I bought my brother out. He wasn't interested, and I was too attached. So in 2020, my business had to close for 11 months with COVID, and since is closing. But I was thankful to have the ability to rent the house, and it was able to sustain my family and I for the last 2 years. It has helped. It's not nearly enough, but it helped. We've had no complaints, as you guys have said. I vet everyone that wants to stay at my home very carefully. It's as I said, I'm very invested. It's not a party home. I have 3 cameras. I count the people that come in. I don't allow animals. I have the noise monitor. I mean, I'm probably on the other side of where you don't want to stay because I'm checking in and I'm talking to them, but it's because the house it's my home. It wasn't an investment. But I do have an extensive contract with all the renters. I make them sign it and text it to me so I know they've read it. I'm a little bit overboard, but I do take pride in this home and what it means for my family. And I really want to provide a nice experience for my guests while maintaining a sense of community. I don't, for my neighbors, it's certainly important. I do have a VHR that's next door, but there's people that are, full-time residents across the street, and I've talked to them, and there's never been any issues. But I just want to kind of address, besides the taxes that my home generates, it also provides jobs for property managers, house cleaners, snow plowers, painters, contractors, roofers, handymen. I mean, it's not just that we take away from this community, we also provide. My guests go to the restaurants, casinos, bars, concerts, golf, ski resorts, tournaments, bike races. So growth happens everywhere, and I know that's been a big issue. I've watched all the hearings since you've been doing them, but it's everywhere. I live in the Bay Area. I was born in Sunnyvale, and that used to be all orchards, and now it's all tech, businesses. So, I mean, it happens, and I get it. And I know what Tahoe used to be, and it's not that anymore. And I understand that. So, I kind of wanted to state that I feel like Tier 3 should be approved on an individual basis, which you guys are working on, but I don't think it's a one-size-fits-all. And with some of the rules or ordinances that have been implied, like you're giving +2 to homes that really can't always accommodate, and the houses that can, that are built for it, like we have more bedrooms, and I'm not talking about, like I have 6 real bedrooms, I don't have a bed in a playroom, I know there's a lot of confusion with that, but I feel like that everything should just be judged by the individual home, and if they can handle the parking, and if they can, manage the amount of people. And I know that the bad owners wreck it for the good ones, but I do care about the community and my neighbors. I just, on the last part, I just wanted to say, like, I spend a lot of time, especially in the summer, in Tahoe. I enjoy it up here. I hear my neighbors that live there all the time. It's the same thing with the last people when they're saying, well, people are pulling out of their driveway. If people live there, they're also pulling out of their driveway on a blind corner. So I get it's hard to navigate and we're all learning, but I just feel like the people that live there also have to be neighborly. It's a two-way street. Yeah, that's it. I think we just all have a responsibility, everybody, to be neighborly. Do you have anything to add?
Thank you. Questions from the board? Keith?
Thank you, and it's very good to hear, that, you do actually live in this house part of the year. I'm going to, and I don't know if you were given the whole packet, but on slide 208, on page 208, it appears to be your house rules that you have posted in the house is what it looks like.
208.
Yeah.
No, I'm not there.
Page 208, it's kind of an off-color sheet, maybe it's brown.
Thank you. Oh, yes.
Yeah, and it goes to my earlier question about who the emergency contact is, because it looks like it's Brandon Gerard, but the address they're using is his office, and then all of a sudden this says Rob Hinkle.
No, so Rob was my old guy, so just as all the previous people that have come up, we have been required to have a licensed real estate person. So Rob he lives here, and I had my cleaner and my handyman were both my contacts, depending on what issue arose. If a window broke, I would call the handyman. If whatever, they needed more sheets, I called my cleaner. Not that any of those have ever happened, but so Rob was initially my contact, but then we had to hire Brandon to be this level 3. And so this has changed. I do have the new one, but when we tried to print this out, the picture didn't work, but I do have the new one.
No, that's okay. And when you look, so when you printed the new one up, item 2, maximum occupancy now says 12 instead of 14?
Yes, I have it here if you'd like to see
Okay,
it.
no, I trust you.
Okay.
So when there is a problem at 2 o'clock in the morning and somebody wants to call the emergency contact, they look online, who would they physically talk to?
I would assume right now it would be Brandon, because these people are not my,
Do you know
I
where
mean,
Brandon?
I would prefer that they call me first, then I can make the appropriate call. So,
Yeah,
I
but
mean,
Brandon, so
that's-
Brandon's on your permit, so if a neighbor complains, looks on the county, they're gonna call Brandon. Do you know where Brandon lives?
I don't,
Crystal, for the record, Brandon lives in the city of South Lake Tahoe. Oh, in the Keys.
In the Keys. I believe that's within 30 minutes, wouldn't it? Yeah, okay, thank you. Further questions?
Chris actually referred him to us, so.
Thank you, Keith. Michael, do you have any questions?
Yeah, my opening comment was that this particular little corner has at least 4 VHRs, potentially tier 3s. And I know you're the homeowner, but have you ever seen that corner just swamped with cars and?
So what I can tell you is I believe I'm probably first. There's only 3, there's not 4. Because like you said, on this side of the road, we're single-family homes, and on that side, they're all like condos and attached. So I don't pay attention to that. It's across the street and up, and I don't really know kind of what's going on over there. But, I mean, I have looked at the map, and I can see all the little dots. But just on my little corner where the 3 VRBOs are, the one next door, it's not a tier 3 because they're only a 4-bedroom house. So I just think they haven't, right? They don't qualify for a tier 3.
Yeah, Tom Delaire for the record. That's exactly right. So the potential tier 3s is the occupancy that we have on file today that is over 10. So it could be a 4-bedroom house where they lose the 4 occupants, the additional 4 occupants from their current permit between now and July 15th. So I think that's part of the problem, because these ones on Gary Lane, which is it's in the condoed units at that point. So those probably won't be tier 3s, but for simplicity reasons in our spreadsheet, we just said potential. That was part of the 84, if you remember the total potential, tier 3s, 84 of them total that we may have coming forward, but that's where this is coming from.
And the other house is a 5-bedroom house. So there's a 4-bedroom and a 5-bedroom, and I'm a 6-bedroom. So I'm the only tier 3, if that's granted.
Thank you. Do you have other questions?
Well, I guess it was just, okay, if they're not tier 3s, they're certainly substantial tier 2s and tier 3s, combinations. And so my question, I think, was, have you ever seen that corner just swamped with cars in and out?
No, I don't know if you have a diagram.
I
So
do.
my home faces South Benjamin. The home on the corner faces mostly Kingsbury. It's kind of directly on the corner, so it's kind of catawampus to me. So, and then the other house is like on Kingsbury in my backyard. So I don't really, unless I'm driving down Kingsbury, I don't. Yeah, there's like a little ledge, little mountain.
Thank you.
So, I mean, I see people there, but it doesn't, affect me.
Thank you. Lauren?
Yep, couple of things. I did see on this, the Welcome Castro Lodge, if I could ask you, it does say, and I'm very glad and very bold, never leave refuse sitting outside, but where do you tell them to take their garbage to if they need to take their garbage somewhere?
It's all in my contract. They have, so I have 2 bear boxes, and if they're just there for 2 nights, I assign 1 bear box that they're numbered and they know where to take their garbage and the recycle, and it's all very clear in my contract. And
I'm just saying, number 7 says, if it doesn't fit into the bear box, it must be removed from the premises by the guest.
yes,
Where do you tell them to take it to, or where are you thinking they're taking it to?
well, it's never happened because if I don't have another renter coming, I let them use the second bear box. But in the contract, it states that they are just to remove it from the premises and dispose of it legally. It doesn't say you have to go to Tahoe Refuse or anything like that. It just says that it has to be taken care of and dumped legally. And nothing is to be left outside.
And maybe since you've heard our past conversations and we're still kind of getting this all ginned up and stuff, it's just very important that VHR owners and all the people that touch the garbage from a VHR understand that they need to take it someplace legally. And I'm hoping at one of these times that we'll get a form that the owner signs, an affidavit saying that they know this, so that it doesn't impose on other residents of the area. So I'm just bringing it up. And so if you could be clear as to where they can legally dump it, that would be
Yeah,
great.
well, like I said, I can certainly
Never
clarify,
happened.
but
Yeah.
it's never happened, and I do have 6 garbage cans
Okay.
in total. So.
We didn't get, I don't see in the packet a picture, and this is our new process or whatever, but because you're using the garage for parking, we just didn't see it. There's not a picture of the inside of the garage.
Yeah,
Is
we weren't asked to give that.
Is it available for parking?
Yes.
Okay. Noise monitor outside, I think, and if I lost the track, that we would have to stipulate that the noise monitor would have to go outside. On the permit, and this might not be for the owner, but on the permit that's issued, isn't the number incorrect, or am I wrong? And I'm trying to find the page. But just because these numbers are going everywhere, the permit that was issued expires 2020.
Lauren, I think this is the one that we had the 2019 permit to 20, and then the 21. We don't have the current permit in our
Gotcha.
packet.
Okay, so we're good there in numbers. Thank you. And then one last question, and then it might be, I'm not exactly sure, but on the packet, it says that there is a signed affidavit from the HOA. Is that true? No?
I don't have an HOA.
Thank you. Okay, I kind of thought you didn't have an HOA, so I wasn't sure where because in the packet for us, it says signed affidavit for the HOA is on file, and I wasn't sure. So that clarifies it. I think those were my questions. Thank you.
Thanks, Lauren. Keith has one more. Okay, go ahead.
I don't know if you had it rented this weekend, or that was you.
That's me.
Okay, so when I drove by, unfortunately, I was trying to do these things hit or miss, and so I came by Saturday night, and the garage was open, and there was a ton of stuff in the garage. That's all yours, and that's because you're there and you take all that, because it was literally a pile
We
of
just
stuff.
had a delivery. I just had 2 washers and dryers delivered, and we took the Christmas tree down, and it's not put away yet. And I just got a chair from my brother, so it's all in the garage right now.
Okay, so, but normally
our
that
kids
garage
were with us, so we
is
didn't.
empty, normally.
Yes.
Okay,
Yeah.
thank you.
So all 3, there's 3 garages, right? All
3
3 are
garages.
available.
All 3
to
are available.
someone.
I
Great.
can tell you that a lot of times they don't use them. They're not like electric. I don't have a button. They've got to get out and manually lift it, and it doesn't happen.
Well, I do like that you included such nice, the evacuation routes and all that kind of thing. That's really great for us to
And
be
I
able to
just
see.
wanted, we have this, I don't know, it was in our packet, but this is we have our noise monitor, and We've sent this several times. I can show you the picture. So this is in our living room. When we did this, we were told there were no regulation, like just to have one, we're like, well, what are the guidelines? Where does it need to be? So this is in my living room and kitchen dining area. And then we subscribe to Minute and we pay a fee for them to monitor this. And they are in the process, I guess, of making one that goes outdoors. So I will get that and I can put that outside at that time. But our only concern that we were thinking about is that it has to be in the Wi-Fi range. And I don't know if it's outside how well that works. Like I said, I'm a rule follower. I want to do what I'm supposed to do, but I just don't know. And we want to get the same one so it can be with the same subscription.
And I'm sure staff will follow up with that, since it's been asked to be put on as a condition if we approve it. So
Yeah.
they'll work with you on it.
You guys should have this, but, okay. Oh, where it is. Got it. Okay, and we were only told we needed one. I can certainly get more. I don't.
Oh, Mr. Delaire?
Yeah, Tom Delaire for the record. One outside, probably on the deck against the house. I don't know how far the Wi-Fi is either. It's going to depend on the unit and the Wi-Fi
I feel like
in
that
your
would be
house,
the best option
Yeah.
because.
Yeah. If you have one inside and one outside, that's really what
Yeah,
I think
I
you're
mean, I
looking
think
for. I don't
when
know
I-
if there's a seating area in the very back yard. It's a pretty fancy deck over the top of your three-car garage,
Garage,
which
yeah.
I imagine majority of people would sit just because the view's probably better from up there anyway, so.
Yeah, and when I called about the Minute, the noise monitor, I said, there's no guidelines, where do I put it? And they said, you should put it on the house, like your closest next door neighbor's house. And I'm like, well, that's far for my Wi-Fi, but I don't know that they would want me to install it there either because their guests are going to make it go off.
Yeah.
I don't, so I don't know exactly still where.
It's just the assembly area outside on the home.
Yeah.
So you're gonna want it covered. I mean, you could put it on the property line somewhere too. I mean, that would work. I understand. I don't have any experience with the Minute
Yeah.
system or noise aware, but you could put them on the property line so you know what the noise level is at the line.
Right.
You know, but if you put it on the outside of it doesn't look like you have a spa on this one, but on the deck where they would assemble or in the back patio, maybe there's a place on the house you can just put it.
Yeah.
And you have one inside and one outside that you can see the differences
do
on.
that.
It's pretty handy.
Yep. Happy to do that.
Okay, unless there's any more questions, Mr. Booth?
Madam Chair, Sam Booth for the record. I just would like to, for the record, state that we do have, to Lauren's question, the HOA affidavit signed by Mrs. Castro, that there is no HOA or CC&Rs that restrict the property.
Thank you. All I just wanted to say is on number 7 of your list with the trash business I'd like to not see it say that it's up to the guest to take it away, because there is no place to take trash in Tahoe unless you go to the refuge company. It's been a problem for as long as I've been around. I've been around a long time because there's just nowhere to take trash unless
Well,
you have a service or that kind of thing.
Yeah.
So I just think that was a little confusing.
Yes,
is
and
all on your,
I can certainly take that out.
Yeah.
I just want to be clear to my guests. Like I said, I'm a
Yeah.
little.
Or maybe they just need to contact you or your property
Well, my
manager.
cleaner takes the
Yeah.
garbage away
Yeah.
typically. If there's extra, like my bear boxes are full, she will take it. She lives
Good.
over here, but,
No, I'm not.
yeah, but
don't know.
I
I'm
mean, it
just-
just doesn't.
You
it
just don't
doesn't
know
really
from one
happen.
guest to the next whether they'll just say, oh, I'll just take it down to Safeway and throw it in the dumpster.
Yeah.
And, that's not proper. So unless there's more questions, I'll call for public comment. So you can probably take a seat.
Okay. Thank you. I appreciate everything.
Hi, Ellie Waller. Most of my questions were answered. I want to thank Mickey for the questions I would have had. I lived in a neighborhood where, again, I was the only full-time person, and so everybody used everybody else's bear boxes, and it is a really good warning. I want to thank the Castro, Jackie, for understanding this is a process. This is probably one of the easiest ones we've looked at in a long time, and I shouldn't say we, you guys, I just come to these meetings. Again, yeah, fixing and being diligent about putting notifications to people need to be very clear for a reason. The simplicity of telling them to take their own trash doesn't work. I think they have 2 bear boxes. Maybe the use of the 2 makes the difference. Doesn't matter how many people, the 2 might just make the difference. It's already installed there. And I too appreciate the evacuation route. I'm sure the fire department does too. It was nice information to have in a packet. Thank you.
Thank you, Ellie. Any other public comment? Ms. Reno, do you have any online?
Thank you, Madam Chair. There is no public comment online at this time.
Okay, then we'll close public comment and move to make a motion.
Before I make a motion, I do want to say that, you know, I kind of have this 100-foot rule. You're a little within that. Your deck is right by it. But I notice 2 things. First of all, there's no complaints. Second is that's also VHR, so maybe that's less. But on this one, I believe that if there's complaints in the future, there is a process to lose your permit. So I'm very comfortable issuing the permit. So I move that we approve the special use permit to obtain a Tier 3 vacation home to Ms. Castro at 242 South Benjamin Drive, Kingsbury Grade, I guess that is. Subject to sufficient agreement with the county on the placement of noise monitors.
Thank you. Do I have a second?
I'd like to ask a question, just clarification, if I may. Is this for 6 cars? 6 cars? And was there any issues with the county for 6 cars?
Madam Chair, if I may.
Mr. Booth?
Sam Booth for the record. Yes, Mr. Sloan, 6 cars, and we had no issues with the parking diagram. 3 in the driveway, 3 in the garage.
Thank you. So I have,
I'm sorry.
Mr. Dallaire?
I just want to follow up with that. The emergency access on this one, it doesn't have it's not elevated to the front door of the home like on the 2 of the others. This one has, you can get to it. The emergency personnel can get to it, you know. So the driveway, I think, is wide enough for 3 cars to park in there as well, and still be able to get the apparatus through and without hitting any cars. So that one we didn't have a problem with this one.
thank you.
No further comment.
I have a motion by Mr. Byer and a second by Ms. Romaine. Further discussion? I'll call for the vote then. All those in favor of approving this special use permit signify by saying aye.
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 No nays. Thank you. Passed 4-0. Item number 6. Item number 6. For possible action, discussion on an appeal filed by Matthew Cavance to contest the $5,000 fine issued relative to notice and order and assessment of civil penalty for renting without a current VHR permit issued in code enforcement case number 21-000192, APN 1418-34112-002. Mr. Dallaire.
Thank you, Madam Chair. Tom Dallaire for the record. So this one came to the board as a Tier 3, I want to say in December. and we continued it. We had found or gathered some information from some of the neighbors who had provided some information on the HOA, which changed the CCNRs in their development back in 2016. And this individual, Mr. Cavance, has purchased the property in 2018. We continued his item, turned around and then notified him that we were revoking the permit because of the date of the purchase of the home. He should have never, Douglas County shouldn't have issued him a permit in 2018. And so, so we revoked his permit after the board meeting. It was about, I think it was right before Christmas, and told him he couldn't rent anymore. And we have this instance, I think it was in December 7th, where the item was continued from you guys. We have the complaint from the neighbor on January 14th, and then code enforcement had the sheriff's office go out and verify, knock on the door, and they verify that there were renters in the home. And when we received that report from the Douglas County Sheriff's Office, we issued the notice in violation on January 7th. It was a $5,000 fine. We're in the settlement stages of the county code, which the district attorney's office informed our department that we could only go to the $5,000 fine, which was what was in code before we changed it in July. So the maximum fine, or a fine, any fine, for renting without a permit in our past code was $5,000, which is what we've been using up until last week. And now we can go up to $20,000 in the fines. But this particular instance was from January. This is what he's appealing. He has paid the fine, and he's paid the $300 appeal fee. And he's appealing, and I think his attorney is here to do his presentation, but yeah, renting without a permit, and he's appealing it.
Thank you, Mr. Delaire. So first, let's take a motion and a vote on whether the appellant the property owner is deemed to have standing and is aggrieved. That's motion number one. And then we'll hear from the appellant's attorney. So can I have a motion on that?
I move that we recognize that Mr. Kabatz and his attorney have standing. Mr. Kabatz is the owner of the property in question. I move that we deem that he does have standing.
I'll second that.
Thank you. I've got a motion and a second that the appellant, as the property owner, is deemed to have standing and has been aggrieved. Any discussion? Any vote? All those in favor signify by saying aye.
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 No opposed. Thank you. Michael?
Thank you, Madam Chair. On page 224 of our package, third line down, there was just I think a incorrect key strike where the address says 1261 Lincoln Circle. It should be, I believe, 1262. And 1261 under background, third line.
Thank you, Michael. The correction is noted. That should read 1262 Lincoln Circle. At this time, Unless the board has questions for staff, the appellant attorney could come up and give us a presentation, state your name for the record.
Jose Tafoya for Matthew Cavance. Do I have to sign in as well? Okay. So, as Mr. Delaire noted, Mr. Cavance owns property in the Lake Ridge subdivision. The Lake Ridge subdivision is in the jurisdiction of the Lake Ridge General Improvement District. As a general improvement district, the LGID, as I'll refer to them, derives its powers from NRS 318. If you review 318, under nowhere in the statute does it say that they are allowed to regulate short-term rentals or implement deed restrictions. In December 2021, December 10th to be exact, the county terminated Mr. Cavance's VHR permit pursuant to the 2016 amendments that Mr. Diller referenced, wherein they banned short-term rentals of under 60 days. The county has since fined Mr. Cavance on January 27th and again on March 10th, which he has also appealed. Miss Bonnie Harwood, I believe is her name, said that we couldn't consolidate the appeals, so that appeal is pending, I'm assuming for next month. But this is just in regards to the January 27th fine. It's Mr. Cavance's position that as a general improvement district under the auspices of NRS 318, the LGID's powers do not include regulating VHRs or implementing deed restrictions as they've done pursuant to the 2016 amendments. Without that authority, the short-term rental ban that they imposed pursuant to the 2016 amendments are unenforceable as to all the property owners, and not only the owners that did not consent to the 2016 amendments. Douglas County Council has previously communicated with counsel for Mr. Cavance and agreed that if this were before the court, which it is now, the court would likely find that the LGID does not have the power to regulate STRs as they have done. Mr. Cavance filed a complaint on March 11th seeking declaratory and injunctive relief against the county and against LGID pursuant to the 2016 amendments and the challenges to those amendments. In the following days, we will also file a temporary motion for a temporary restraining order and preliminary injunction because Mr. Cavance at this time is suffering irreparable harm, and the merits of that will be outlined in that motion. And County Council has indicated as well that if a court deems the restrictions unenforceable as to all property owners, the permit at that time would be reinstated. So that is the basis of Mr. Cavance's appeals, and I will take any questions.
Thank you. Questions from the board, Keith?
Madam Chair?
Oh.
Before we get to questions, I would like to clarify one statement that Mr. Tafoya made, if I may. Yeah, Sam Taylor for the record, Douglas County DA's office. I just wanted to clarify for the record, Mr. Tafoya said that that basically I said that Lake Ridge GID lacked the power to regulate CCNRs, and I just want to make it clear that I never said that. I said Lake Ridge GID lacks the power to enforce CCNRs, which is utterly different than regulating them. I don't necessarily agree with the position of Mr. Tafoya relative to the Lake Ridge GID's involvement and relative to assembling the parties and the homeowners together and having a vote. That is not something that I've ever weighed in on or said, although if you could take a look at page 235 and 236, my discussion with Kara Thiel about the Truitt decision and Douglas County Code and how it applies to CCRs is made part of the packet. And I would note for the record that you can see clearly that I never said the word regulate with respect to the Lake Ridge GID. Thank you.
If I may respond to that. I believe it's on 235. It might be on 236, mine cut off. But Ms. Kara Thiel, who was counsel for Mr. Cavance at that time, says, were the issue before the court, we are confident it would conclude that the Lake Ridge GID lacks the authority to regulate short-term rentals, among other things the GID engages in. The GID is not an HOA under Nevada law, to which council responded, again, we agree.
Thank you.
Just for the record, if I may, Madam Chair, I want to clarify my point with respect to that. What I meant with regard to that particular response is regulating meaning enforcing the CCNRs. I will agree that the word regulate is there, but I do not agree that that is something that the Lake Ridge GID was precluded from doing. Thank you.
Thank you. Questions? Keith?
Yes, sir. I'm sorry, I have a timeline here, and I'm just trying to place some of your statements in this timeline. You said there was a request for injunctive relief, I believe?
Yes, so that was filed on March 11th, to my
Sorry.
understanding.
March.
It was a complaint for declaratory and injunctive relief filed on March 11th. To my
Okay.
understanding, the county was served with that last Friday.
Okay, so March 11th. And was that injunctive relief granted?
So we haven't filed an application for a TRO and injunctive relief. Right now, it's just a complaint seeking declaratory and injunctive relief. To my awareness, the county has not yet filed an answer, and we are still working on serving the LGID. So beyond the complaint, nothing has happened in that
Okay,
case
so,
yet.
so just to be clear, so a court has not granted injunction relief?
Correct,
Okay,
but
okay.
since the matter is being litigated at this point, Mr. Cavance's position is that it's not appropriate to be imposing fines and threatening criminal prosecution when the validity of the restrictions that the county is basing its code on is now being challenged.
Sorry, just to continue, was there any request for injunctive relief prior to his rent, between the time that he received the letter saying that his permit had been denied, were there any court filings or requests for injunctive relief between there and the time that he rented his house?
At that time, there had not been any fines, so there was no basis to seek that because the county had not fined or threatened criminal prosecution.
Thank you very much.
Okay. Michael?
Thank you, Madam Chair. Thank you for coming today. Was your client aware that he was informed that he no longer had a valid permit to rent short-term rentals?
Are you referring to the December 10th letter?
Yes, and subsequent letters after that.
I can't speak as to whether he knew because we weren't engaged as counsel for him at the time that he was issued the December 10th letter. But, you know, obviously the letter has been received now.
Are you aware if your client rented short-term rentals after that date?
So this is outlined in the complaint to the extent that there has been rentals. It has been fulfilling and satisfying the contracts that he had already entered into. For example, the most recent March 10th fine was based on an incident that the Douglas County Sheriff's Office investigated on March 5th. On March 5th, the Douglas County Sheriff's Office made contact with someone on the property who had indicated that they had entered into this rental agreement with Mr. Cavance in August of 2021, nearly 4 months before his permit was terminated.
Thank you.
Lauren? No.
I'm sorry, I missed that last part. What you're saying is that the DCSO people there went to the property, asked, and they were renting at the time, but they entered into that agreement 4 months prior. Is that what you're saying?
So the Douglas County Sheriff's Office investigated and questioned one of Mr. Cavance's tenants who informed him that he had booked the property in August of 2021, which was nearly 4 months prior to the December 10th termination of the permit.
But the person was renting at the time.
Correct.
Yeah. Okay. No, the other questions I had were asked.
Okay, so the tenant that was renting, was renting from Mr. Cavance while he did not have a current permit, whether he booked it months before or not. When he showed up on the property, there was no current permit on file, is the way I understand it. Is
The
that correct?
permit was terminated December 10th, correct?
Right. And so no room tax or anything was paid?
I'm not aware of room tax. I would have to talk to Mr. Vance about that, but I'm not privy to that information at this time.
Okay. Michael? No? Well, yes, Michael.
Trying to find emails here. Let's see here. Prior to you coming on board, there was a Kara Thiel, that was the
Correct.
attorney, correct?
Correct.
And in one of her emails, she stated, I believe in an email to Mr. Stam Taylor, that, you know, my client is no longer advertising, you know, at this place. And so it appears as though counsel informed Mr. Cavance that, you know, hey, we're not going to rent anymore. Do you have a response to that?
So again, I'd be happy to provide the board with a copy of the complaint. Like I said, Douglas County has been served. I'm not sure if it has to go through Mr. Taylor. I can provide a copy of the complaint, but some of those things are addressed. Mr. Cavance, his permit was terminated. He's still mitigating his damages pursuant to that. So even though he's not advertising new rentals as shown by the rental from August 21st, he's still attempting to honor the rentals that were already in place, because as you may well be aware, a lot of these people book these trips months in advance. And so it would cause irreparable harm if he didn't honor any of these. And so in an effort to mitigate his damages, to the extent that there was already rentals booked, he was trying to walk a fine line between following county code and honoring these contracts while this matter was litigated.
One follow-up question, if I may. Do you know about how much income Mr. Cavance made since the letter revoking his permit?
I do not.
Thank you.
Keith?
I'm sorry, you're dealing with non-attorneys. You use the word irreparable harm, which normally means you can't repair it.
Right.
And this is really money, which is almost fungible. So if Mr. Cavance, when Mr. Cavance agreed to the rental over, I'm assuming, a VRBO or Airbnb, if he had canceled that reservation, what would his liability to either Airbnb, the rental agency, or the renter be? I've had people cancel the day before I was supposed to arrive, and I didn't get any money. And so I guess, can you define in layman's terms what irreparable harm means? And can you tell us what the fines and what the penalties Mr. Cavance would have had to pay had he terminated these pre-existing contracts?
So you actually defined it pretty well yourself. In terms of irreparable harm is essentially money can't make it right. And so when you look at the situation, he's being threatened with criminal prosecution, a threat to his civil liberties, and an ultimate action on his civil liberties would be irreparable. Any damage to his profile by poor reviews on these VHR websites would be irreparable, even if the court comes down a few months down the road and determines that these deed restrictions are unenforceable. Those poor reviews from him not fulfilling any of these agreements would stay on his profile. So that would be irreparable. And this will be outlined more in the TRO, but just to kind of explain it in the context of what you want, what you requested, that in the context would be irreparable.
What would his monetary losses have been had he canceled these contracts?
I'm not aware of the monetary losses.
Thank you, Keith. Anybody else? Ms. Michael?
Madam Chair, I have a question for council. regardless of how we decide to go today, is an appeal to the Board of Commissioners a next step if the client so choose to do so?
Sam Taylor for the record, Douglas County DA's office. Yes, appeal can be taken to the board. Although the question becomes whether or not, if they file a TRO, get some sort of injunctive relief, whether or not that would include the appeals process. My guess, if I had to, that it probably would. They would want to stop and halt all actions against their client, which would include the ability for the board to impose fines or otherwise hold the appeal valid, or I guess based on whatever your decision is here today. I mean, if you decided that their appeal is valid, then I guess they probably wouldn't do that. So,
Thank you.
Mr. Delaire?
Yeah, Madam Chair, Tom Delaire for the record. I just want to make sure everybody's on the same page. If you look at page 265 and 266 of the packet, we did research right before, the week before, we posted this packet, and you can see on those pages, we highlighted in a cloud stating that the listing was removed on December 21st. That was the day that the refund for his permit renewal of $1,800 was refunded to Mr. Cavance. He does not have a permit from Douglas County to rent his house out as a VHR. And then December 22nd, the day after, the advertising was removed. In January, he had 3 documented stays. And then the listing in Airbnb was reposted on February 2nd, 2022. The listing on Airbnb was removed on February 4th, so 2 days he had it posted. And 1 documented stay in February. A listing on Airbnb reposted on March 3rd. It wasn't removed, if you look at page 265, it wasn't removed until March 12th. So he continues to act like he has a permit from Douglas County, and yet he does not have a VHR permit from Douglas County. And we refunded all his money, even though his renewal was in October. I believe it was October is when his permit was supposed to be renewed. And we refunded it in full. So I just want to make sure you guys are seeing this, that just really shows the trends that are happening at this house. And if you look at page 363 or 263 and 264, this is from Deckard Industries. It's the new software that is being used, and it's based on a calendar. And you can see in January the highlighted days in light blue versus dark blue on the image there is the different bookings that were taken for this property, and some of them are before we revoked his permit, and some of them are not. And then the second page on 264, it shows March and April, and you can still see bookings are being done or are still on this piece of property in the future. And then host also, the Deckard properties, it shows how much the host revenue is. There is a table there. You can kind of get a glance anyway from what they can drag out of the information and how much they're renting it for the night and how many nights this information is tallied, and it is totaled there. I am still trying to get HDL to verify this information and see if TOTs have been paid, since December. But when I asked them about it 2 weeks ago, no TNTs have been paid since we revoked the permit. And so I just want to make sure that that's on the record as well. And I can tell you, we've got the history of the entire property in the packet. So I just want to make sure you guys were aware of that and put that on the record.
Thank you, Mr. Delaire. Yeah, the packet's very complete. Thank you. Unless someone has more questions for the appellant.
I just want to make sure, I think I'm near done, but I just want to make sure I'm understanding what Mr. Delaire is telling us. I'm on page 1 on 264, and I'm trying to read the code of the colors, because booked up in the upper left-hand corner, I'm looking at the calendar, is like a dark blue and a light blue. And then in the calendar itself of March and April, I see dark blue, light blue, and no. So are both dark and light blue booked and that the uncolored items are unbooked? Or is the dark blue booked and the blue is unbooked? Can you give me the color
Yeah.
code that means? I'm sorry, I didn't understand what that meant.
Yeah, no, this is what we deal with every day. This is so much fun. So the dark blue and the light blue is booked. Those are, so what happens is you have a separate booking in light blue on, let's just look at January. January 1st and 2nd was one booking together for that weekend. A separate booking for the 3rd, 4th, and 5th. A separate booking for the 6th, 7th, and 8th. It tells you when you hover over that week or those 3 days on the dark blue, it'll tell you when it was booked. And those are different dates. Based on the booked. And then the white is it wasn't rented. The home was occupied, you know. Right. Yep. Yep.
Thank you. Michael, do you have?
So I have one more further question, I'm sorry. So you mentioned that, he was trying to just honor his bookings that he had from October when, they went in March. But are you aware that he is still booking and still renting without a VHR permit?
I have not had the opportunity to do due diligence on these particular graphs, so I can't answer that right now, but I will point out that, for example, there is an indication that, for example, he opened up rentals again or booked rentals for February 4th, and I believe in the Douglas County Sheriff's report, it does indicate that when they made contact with the individuals on February 4th in Mr. Kansas property, it was actually Mr. Cavans himself. So that there is some questions of fact as to these charts, and I'll have to do my due diligence on them to fully address that.
Thank you.
Lauren, do you have anything else for?
Just a statement. I mean, I'm looking through this timeline unless I'm missing. I mean, I understand that there's the conversation, this kind of outside conversation, as far as I'm concerned with the VHR stuff. Our code is fairly clear that you have to have a current and valid permit in order to advertise. I'm thinking there's another verb in there, advertise something and rent. And I'm just seeing that Douglas County has done what they needed to do to notify him. And he got his money back and didn't have a valid permit and continues to rent. So unless somebody on the board can correct me with what I'm seeing there, it's thanks.
If I may, the scope of Mr. Cavance's request in this appeal is to cease these fines, cease these threats of criminal liability while this litigation is pending, because we are very confident in the merits of the case. We are very confident that when it does go before the Ninth Judicial Court for a decision, they'll deem that as a general improvement district whose duties are paving roads, constructing sidewalks, in those powers are not powers to regulate or enforce short-term rentals. And so in the appeal process, it said, statewide fines would not be appropriate at this time, and that's the basis. This matter is actively being litigated. The validity of the LGID's power to enforce these deed restrictions that the county is relying on are now being litigated before the Ninth Judicial Court.
Madam Chair?
Okay, Mr. Taylor?
Yeah, if I may, I would just like to clarify a couple of issues that I think might help the board with respect to this. And again, Sam Taylor for the record, Douglas County DAs. First, we believe the Truitt decision, which established, basically how these CC&Rs are, one, to be created, amended, and passed, and become effective, was discussed in the undisputed findings of fact in the Truitt decision by the judge. Basically said, hey, if you, the homeowners, want to amend this, 51% of you have to vote in favor of it, and then 2, you have to record the results of that election. The judge did find that the election occurred, that 51% of the residents did vote in favor of the amendments to the CCNRs in 2016, September of 2016 to be specific, and that those CCNRs were in fact recorded. So those are findings of fact that are on file with basically Judge Gregory's findings in the Truitt case. Unfortunately, as Mr. Trefoy can probably tell you, we're bound by that court decision until such time as another court comes along and says, no, that's not the case. Because it's binding on us, we have to follow it. And so that is what Douglas County has done with respect to those particular CCNRs and the applicability of those CCNRs with respect to Mr. Conveyance. I understand where Mr. Conveyance is coming from, why he filed the lawsuit. Obviously, he wants to continue to rent. And if he gets a court to basically say, yeah, you can rent, hey, fine, Douglas County won't honor that court decision. But until that happens, we're kind of stuck between a rock and a hard place, and we have to follow what has previously occurred. Thanks.
Thank you, Mr. Taylor. I think we're ready for public comment. So we will go to public comment.
If I may, one more comment as to Mr. Taylor's last comment. The court in Truitt, did decide the validity of the 2016 amendments, but it did so in respect to consenting and non-consenting owners and whether the deed restrictions were new or pretty much a revision of the existing ones. In a footnote near the end of the decision, the court specifically declines to address whether the LGID has authority to enforce these deed restrictions as they're now doing. And so that is the crux of this case, whether the LGID has that authority in the first instance. And if they don't, then these aren't enforceable as to all homeowners. And on that basis, Mr. Vance is requesting that his appeal be granted and he's allowed to rent while this litigation is pending.
Madam Chair, if I may, I would like to respond to that.
You go right ahead.
Okay. One of the important points I think that really needs to be hammered home is the question that the judge was addressing in that footnote that Mr. Trefoy just mentioned was the power to enforce the CCNRs. What the GID was doing was fining Mr. Truitt for failing to comply with the 2016 amendments. And what the judge found, Judge Gregory found, was you cannot retroactively apply these amendments. Mr. Truitt bought his home, I think, in 1984, and the CCNRs that were in place at that time were what was applied to Mr. Truitt, because that is what his expectations were when he purchased the home. The CCNRs in place at the time, and that you cannot retroactively apply CCNRs to someone who has purchased. That is why they were calling non-consenting and consenting. In addition, that also goes to the conversation I was having with Miss Thiel at the time. I had a telephone call with her, and she was discussing with me not how the GID was assisting the homeowners with amending the CCRs. Rather, our entire conversation was premised around whether or not the GID had the power to issue fines. That is why the word regulate is confusing, but it was the entirety of our discussion was whether or not the GID had the authority to issue fines. And my position was, no, they do not. They do not have the power to enforce the CCNRs. But again, it was my position and still is that the GID could assist the homeowners with conducting the election. So, and that is, I guess, what we're going to litigate next, right, Mr. Trefoy?
Yeah, and if I may respond to that one final note. The restrictions themselves were proposed by the GID. These restrictions didn't come out of the blue. They were proposed by the GID. As a general improvement district, they proposed short-term amendments to the CCNRs, despite their duties being limited to paving roads, fixing sidewalks, electrical. And so even if 51% of the voters voted for them, they were still proposed by an entity that had no right or power to propose them. And with that, I'll leave it to the board to decide, but I appreciate everybody's time, and pending any further questions, I'll take a seat.
Thank you. I think We're going to call for public comment now.
Thank you.
Thank you.
Thank you, Ellie Waller. I agree with the denial. Thanks, staff, for providing a comprehensive file. I wasn't going to read this, but this is clear if everybody read the correspondence between Kara Thiel, Tom Delaire, and subsequently Sam Taylor, December 10th, 2021. Douglas County agrees that the Lake Ridge GID lacks power to enforce deed restrictions or CC&Rs. However, as discussed in our letter to Mr. Cavance, this is not the GID or its powers, rather that it is the CC&Rs. This is very similar to the B&B one that we listened to recently, and it is upon the homeowner to understand what the current CC&Rs are within purchase. I could go through and read some more of this. I don't think it's necessary, but then we come down to Douglas County staff are obligated to enforce the valid deed restrictions and CC&Rs prohibiting VHRs per the cited code language above, and it talks about the code. Mr. Cavance should have notified Douglas County of the restrictions when he was applying for the most recent permit and did not. His omission could result in a separate fine for falsifying information on his application. So I think that, you know, in the crux of it all, is what the little back and forth here was. On to my next questions. Has TOT been paid? Have listings been removed? Has staff received the DSCO report from March 3rd on the subsequent violation? And Tom, thank you for clarifying that additional fines can be assessed for this is a repeat offender, and please take in consideration if Mr. Huckbuddy doesn't get on his complaint. Thank you.
Thank you, Ellie. Public comment?
There we go. Yes, Madam Chair, members of the board, my name's Wayne Wilson. I am a resident of Lake Ridge. Now, we've kind of gone through this whole battle about the GID having the ability to enforce, regulate, et cetera. Now, with all due respect to Mr. Taylor and counsel for Mr. Cavance, I'm also a member of the Nevada State Bar. I might have a different opinion. And the answer to that it may be based, maybe not on 318, NRS 318. The GID is a property owner, just like I am. And those deed restrictions apply to every property owner, and every property owner has the right as a property owner to enforce the deed restrictions. It has nothing to do with whether they're a GID, whether it's a LLC that owns a property in the area, whether it's a family trust, whether it's an individual. Every property owner has the right to enforce those deed restrictions as a property owner, not as a governmental agency. So the question is whether the GID is going to enforce that, whether I personally or any of the other residents that live there and have that right to enforce those deed restrictions. So while there may be 3 attorneys in here and they're sartorially more attired than I am, none of us is wearing a black robe. And the issue about the deed restrictions is something that's going to have to be determined and dealt with elsewhere. Because with all due respect to the members of the board, you folks don't have black robes either. And you are constrained, and I think, you know, Mr. Taylor's made it clear in his emails that have been discussed that hey, you're constrained by the county ordinances. The county's constrained by the decision that was rendered, finding that there were deed restrictions imposed, voted on. And so this will play out apparently, because apparently there's a complaint filed. But I'm pretty sure, Mr. Cavance's counsel, well, if he wants those deed restrictions listed, he's not going to get away with just suing the GID. He's going to have to sue me and every other homeowner. So it'll be an interesting battle because there's 80 lots in Lake Ridge, and I see my time is up, but hopefully you will see it right to go ahead and sustain the fine, because otherwise he's going to continue to rent, and we're going to have this problem of an unpermitted VHR in our subdivision in Lake Ridge. And I just don't think that's acceptable. It's kind of waving at the County of Douglas with less than all 5 fingers. So
Thank you, Mr.
thank you for your time.
Madam Chair, can I just respond to one thing?
Sure.
Okay, I agree with Mr. Wilson on pretty much everything that he said with respect to the enforcement on the civil side. Yes, as a landowner, I believe the JID can enforce civilly, the restrictions if it so chooses, but it cannot issue fines, which is what the basis of my discussion with Ms. Thiel was, whether or not the GID had the authority to issue fines. That's the enforcement that I was talking about, not necessarily civil enforcement as a landowner. Just wanted to make that clear, and I agree with him in part and disagree with him in part. I think Mr. Wilson would agree that landowners cannot fine neighbors, right, under with CCNRs?
Thank you, Mr. Taylor. Is there more public comment from the chambers? Is there public comment on Zoom?
Thank you, Madam Chair. Ann Reno for the record. No, there is no public comment on Zoom.
Thank you. Then I'm going to close public comment, bring it back to the board. Our job is to uphold the ordinance. And so I think I'll listen to my colleagues here, and hopefully the word GID won't come up again.
Madam Chairman, I don't intend to ever to use GID at all, except that one time I just did. The county revoked the permit, refunded the fees. Mr. Cavance rented his condo without a permit. If he believes the county withdrew that permit incorrectly, there are court avenues that he can pursue, and that court, if they rule that it was incorrect, could also look at this fine that we're doing, that the county has implemented. But I move that we deny the appeal of Mr. Cavance to contest $5,000 fine issued relative to notice and order of assessment civil penalty for renting without a current VHR permit issued in code enforcement case 21-000192.
Thank you, Keith. Do I have a second?
Second.
Thanks, Lauren. Is there any further discussion on this? Then I'll call for the vote. All those in favor I want to make sure I say this right, to deny the appeal of the $5,000 fine for renting a vacation home rental without a permit. All those in favor of denying signify by saying aye.
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 4-0. Thank you. Item, what? Well, I need a second. I want to ask the board if they want to continue item 7 to our next meeting, since we've had a long arduous day, and we weren't going to vote on anything today. Anyway, it was just a matter of some more recommendations, and I will hear
Ma-
what
Madam
you
Chair.
all think. Mr. Taylor?
Madam Chair, if I may, Sam Taylor for Douglas County DA's office. You don't necessarily have to continue. You can just ask staff to re-agendize it, and it'll get you to the same place without having to do a motion.
Madam Chair, I would rather have a robust conversation than a short conversation, given the time of day, the issues we've dealt with, the seriousness of these issues. I would prefer not to take up another agenda item at this time and to talk about it at a later date. But I have all night if you guys feel differently.
Michael?
See how rummy I am? I can't even hit the... There. Yeah, I would like to move it to the next meeting. Thank you.
Lauren, are you in agreement?
Yes, I am. And I just want to thank probably Mr. Delaire for the table, which really makes me excited because I'm thinking we really are going to get to this part of this discussion and really truly move this forward. So I'm excited, but I look forward to the robust discussion as soon as we can fit that in.
Thank you. Then we're going to delay this agenda item, or what? Re-agendize this for next meeting. Mr. Booth?
I hate to chime in at this point, but this is a for possible action item. Mr. Taylor, do we need public comment?
No, actually, you don't. We have opening public comment and closing public comment under the OML. All that's required is opening public comment, closing public comment. It's up to the chair to decide whether or not public comment is appropriate on any given agendized item.
Thank you. That said, then let's go to closing public comment.
I want to thank all of you for delaying it. I was at a meeting till 9 o'clock last night for Washoe County, so this one's really short for me today, so I appreciate that. And again, looking forward to having a robust discussion, also a potential workshop of sorts. So when you bundle, we're not coming back a bunch of times to the board on recommendations. I know it makes it a little tougher on staff as well as the board to have too many to address at one time, but do we want volume or do we want it spread out? Thank you.
Thanks, Ellie. Any other closing public comment? Ms. Reno, do you have anybody?
Thank you, Madam Chair. I do have public comment online. Ms. Gunter, if you can hear me, please state your name and your 3 minutes will begin for closing public comment.
Hi, everyone. My name is Heidi Gunter. As you all know, I'm the owner and operator of... Can you hear me?
Ms. Gunter, you're breaking up.
My internet is acting up.
We can't hear you. Can you hear us?
I think my internet just came back on.
Go ahead, Ms. Gunter. Your 3 minutes will begin.
There we go. As you know, I am the owner and operator of World Class Property Management. My husband and I, we live here full time at the bottom of Kingsbury Grade also. I would like to request that we are involved in any kind of a workshop that goes on with any ordinance changes, being that we have 13 years experience operating within the vacation rental system here in the lake. I think we have a lot of really good feedback to give to this board. and I really want to be involved in any of that. I am going to be gone on May and June. It would be awesome if that could be held anytime before then. Thank you.
Thank you, Heidi.
Madam Chair, there is no further public comment.
Darn. Thank you, Ms. Reno. With no further public comment, we can adjourn this meeting.